He has already died.
Yes, sir. I have already solved the copy.
132, my lord.
132. Will have been 93 by 2000.
130. 1 minute.
Pardon to mention.
1 minute. Let me complete, sir. Yes. 130. There are 3 appeals.
No, 193. I am putting 93.
193.
Only 93.
The first
93.
item, my lord.
Rajiv.
Rajiv.
And what about the other 2 appeals?
Well, other two appeal, but August, I pay for time.
Okay.
93.
93 of 2000. Huh? There are
Death certificate.
death certificate.
Okay.
One.
That is, counsel for the appellant has placed on record the death certificate of the appellant by a memo today. It appears from the certificate that the appellant, sole appellant in the present case has expired on 31/1/2020. In view thereof, the appeal stands submitted. Everything. Memo is taken out of court.
No, so far
My
the
lord,
appeal number.
And so far as
My lord,
the other 2 appeals are concerned, let it be there in the weekly list whenever you are.
No, two separate items.
My lord,
I will not
in-
take before 2 weeks.
My
Don't
lord,
worry.
in-
Let me check. Don't worry.
May I, ma'am?
Nothing that you come just now.
No, don't worry. I'll not take it. It won't reach.
my lord, sir, may I? My lord, in that item,
Nothing for that, I am saying that if lordship taken up immediately 126 on.
After 2 weeks,
my lord, in these
put
two
it down.
sub,
After 2 weeks only we'll take it up. Okay.
my lord, in these two sub items, paper books are ready, maybe served on me, my lord. In-
Then the character here 102 of 2000 and
212 of
212 of 2000. Paper books of the appeal are ready. The registry is directed to supply copy of the paper book to Mr. Rajvi. The matter is ready for hearing. Please after 2 weeks. Huh?
Grateful.
Item number
Yes, one
148.
after another. Yes.
Madam,
Let him-
pardon
let
to
us
mention.
start from this way. Yes.
My lord may recollect the revision by against conviction under 38 NI Act. My lord has allowed my memo to 24th July, but it has not been listed. My associate mentioned on.
What do you want?
Last Monday, ma'am, telling the facts.
Hmm.
Last Monday, my junior was mentioned. My lord has allowed the 3 memos to 1st July. My lord has directed me to inform the petitioner's counsel to deposit the amount.
Hmm.
He is ready to deposit the amount. But by mistake, the memo has not gone to the section. That's why that not.
Well,
listed.
list it.
Two more,
Tomorrow.
two more, madam.
You have argued the full matter. Tell tomorrow. Nothing. Yes.
Item number 140 under criminal appeal 66 of 2004. Mr. A.P. Bose is appearing today on behalf of the appellant. So name may be mentioned in the cost title and kindly taken to.
Name
Mr. A.P. Bose.
AP Bose. Right, AP Bose name may be reflected.
One-
140.
Sorry.
140.
Yes,
This will remain in the weekly list. Get ready. Huh? It won't reach so easily. Get ready. Okay. Yes.
Page number 1, item 1 to 3. Page number 2, item 4 to 8.
Madam, may pardon to mention. Item 7. This is a transport brief. The appeal memo is not with me. Last week I have served the copies of the miscase file to the standing counsel officers. I pray my office memo be officially directed to serve me copy of appeal memo so that I shall also.
It is your appeal and registry will supply.
Or I will apply
You
certificate copy
reconstruct.
to take.
No, what certificate copy you get the pen drive and take it.
The minor of direct I will get it.
Ah.
If my
Comes
minor
for
of
the
direct-
then comes for the appellant petitioner submits that he has lost his brief. He wants to reconstruct the file. He may obtain the copy of the paper book of the appeal revision. Appeal है ना? This is
Appeal, appeal.
appellant करना ना? Petition. Appeal from the registry in a pen drive.
Yes, sir.
Yes.
Let
Give
me-
in a pen drive and finish.
Well,
Yes.
Next
You
week,
come here and take it.
I'll give. Tomorrow I will take it
Ah.
because
Yes.
today I have not.
Yes, list the matter after 2 weeks. ठीक है?
Next week.
Next week, okay, no problem. Yes, yes. Yes.
Page number 3, item 9 to 21.
I will pardon my.
14, my lord. My lord, this is the revision filed by Vigilance against the discharge petition.
Hmm.
Certain copies I have
14.
applied for before the Vigilance code. I have not received.
Are you enjoying the stay?
No, madam, it is revision.
Item
against
14
the
of
discharge.
2008, my lords.
But nothing survives. I will dispose it.
My lord,
Again, this is against charge. There was no stay, 2008.
Might have-
By now, everything might have been over.
proceeded for this.
Unnecessary.
my certain documents, sir. Next,
No,
week,
not document. What document? I'll see.
Leave may be
wait,
granted to him.
Wait.
my lord, Madam.
When the matter come, we'll see.
no, no,
Next.
they are not another matter.
2008
I
against
can't-
charge. Today we are in 2024 and you are asking an adjournment.
My lord, next week
There
because
should be limit.
well, that I
2
understood.
o'clock.
Well,
2
understood.
o'clock. He
My
will
day
seek
3 is
instruction.
going
No.
on. Day 3 is
Please,
going on.
please.
My day 3 is
Please
going
bear
on.
the court for some time.
I consider that. Let it in the board.
Tomorrow.
No, day 3
Nothing.
is going on.
No, tomorrow. Charge against charge.
Friday,
I can
Friday.
understand if there was a stay. I can understand.
My Friday issue. Sorry, day 3 is going on. That's it. I am difficult.
What is going on?
Day 3 is going court not Friday. Friday issue, sir. I think.
But nothing
it's
is there.
not
It's all right.
In my absence, my junior cannot.
Learned counsel for the 14. Learned counsel for the petitioner seeks an adjournment. Mr. Das, learned counsel for the state, submits that this is an petition arising out of framing of charges. Order against the framing of charges. So in the absence of the stay of the trial court proceeding, trial has already proceeded substantially. Therefore, nothing survives in this matter. Since the petitioner, counsel for the petitioner is seeking an adjournment, leaves the matter on Friday, and it is made clear that no further adjournment shall be given.
But I mean, part of trial is not proceeded because discharge person has been allowed by the vigilance judge. Challenging the order passed by the vigilance.
It's all like, let it come Friday. I'll apply.
You say charge is framed.
No, man. Challenging the discharge person has been allowed by learned vigilance court.
Who is challenging?
No, state,
Vigilance Act.
it's just
State
state.
is challenged.
At a state case.
Simply adjourn karo. Simply adjourn. Discharge, he has already been discharged. You said otherwise.
No. State has filed this one.
That's right. I thought it is otherwise.
He said, but not said the charge has.
I thought it is otherwise. If he has been discharged in 2008,
We have to.
still you are insisting for this thing.
No, that's why I'm not.
No. I thought it is otherwise. Charge has been framed and stay is not there.
No.
It is otherwise. Simply adjourn for Friday.
But same page.
Right.
Item
Friday,
eight-
but no further adjournment.
No,
shall be-
I
Yes,
will accommodate.
yes.
And item 18 on behalf of Mr. Divedi, the file has been listed. I will take.
Today you have decided to go home early or what?
No,
You are mentioning since morning.
No. Go to court no file.
I think he wants to go home.
No, not to go home. Go to court no file.
Yes, 18.
Item 18 on behalf of Mr. Divedi, I'll take out on pen drive. Let it come next week. I will argue this case. 3 years conviction. I am searching it for only appeal memo. Period order.
Okay.
Next week I'll take it on pen drive.
Next week.
Next week I'll pen drive.
Pen drive. You take it.
Oh,
Standing
okay.
instruction I have given.
Okay, ma'am.
17 and 21.
17 and
21.
21. 17.
No
Yes, sir.
instruction. 17 and 21, no instruction.
No instruction. This is against the conviction.
I don't know. They are not responding, so I have not seen the file. 17 and 21.
Just check it up. Who is there? If it is against conviction, then we have to ignore. No. If it is against conviction,
No,
if
not
he-
conviction.
then
21 lords.
That
17
might
and
have-
21.
As your lordship was saying, that might have been disposed of. Might have.
yes.
But I don't have any instruction and I don't.
17 and 21 round कर देतो sir आपण आसून तरी I'll take it up huh? I'll take it up. You just
My lord, item 9.
you are free sir, no problem.
My lord, item 9. On
No,
the-
Lordship I record, no instruction.
No sir. Mr. Himanshu Mishra, learned counsel for the petitioner, submits that he has no instruction on behalf of his client, namely the petitioners.
In item
Namely
17 and
petitioner.
21.
1 minute, I'll go through the files when the matter is called up. I want to make him free in both the matters, 17 and 21. Rest of the things I'll give detail. Yes.
My lord, item number 9. Item number 9, ma'am.
Yes. 19, yes.
will take the copy by
Pen drive, yes, take it next week. Sir.
next week.
Yes. Yes.
My lord, item number 9, on behalf of Mr. Rautrai, your lordship. Can it be taken up on next week?
9,
Item number 9.
yes. 2011 matter.
My lord, due to ill health condition, he has informed me over telephone. He has not came to the court.
So he's not well.
Not well yet.
So keep it on Friday. Friday. Yes. Any mentioning? No. Start.
Page 4.
No. See, the few people are there. online. Online?
Page
Okay, sorry, I'm so sorry.
Page 4, item 22 to 33. Page 5, item 34 to 50. Page 6, item 51 to 67.
Well, item 54 and 66.
54.
54 and 66.
Hmm.
These are all matter, but I was absent. I've come yesterday night only. Let it come 2 weeks after if possible.
Let it remain in the board. I'll just
All right.
note it
Why?
down.
That's what
When
I
the matter is called up, don't pass it over for 2 weeks.
obliged.
My lord, item number 64. Last week it was there. I have requested your lordship to take up this matter after 15th. My lord, I have some personal difficulty. 64. Your lordship may note it. Let it be there. So I will do it after 15th. I
No
have some
problem.
personal-
Don't worry. Don't worry.
And so also, my lord, item number 182 also.
182 and 64. Let it remain in the board. No
Yes.
problem.
Yes,
Yes.
obliged.
Page 7,
Item 53, pay for 2 weeks.
53.
3.
Look on 12 matter.
Yes.
Why?
Sir,
Why you ask? What is this matter is about? Don't know. Get the file and mention it tomorrow. Okay? Get the file, read it and mention. Don't
Yes.
mention like this without file and all. Read it. What is the matter? Any court can ask anytime. What is the matter? You should be ready to tell it. It is against conviction or whatever. You must read it tomorrow. Huh? Mention it tomorrow. Yes.
page 7, item 68 to 80.
Pardon, item 68. I'll take 2 years conviction, I'll take the pen drive next week.
Yes. Take it. Let it be there. It won't reach.
Pardon to mention, my lord, item 74.
Yes.
Item 74, I am checking for an 1 week after your lordship, as because I have to take some.
It will
instruction.
come after 1 week only. 74.
Yes.
Appeals will be heard. 1 or 2 appeal I can hear.
74 and 81. my lord.
Let it be there in the board. No problem. Yes.
Page 8, item 81 to 95.
These matters will not reach. Why unnecessary? Your colleague. Leave it.
Item 87, my lord. I am in virtual mode.
Yes,
Item
yes.
87.
Huh?
I'll obtain the records from the court file by through a pen drive, my lord.
You
Let
do
me-
it,
let
no
it be
problem,
there.
because this is in the weekly list. It may not reach
My lord,
So-
my lord.
quick, so you get it. No problem. You need not
No.
tell. I have given standing instruction to my staff that you
Yes,
can
yes.
get.
I'll prepare a note chart and date chart. I'll argue the matter next week, my lord. Against the order of conviction, 3 years conviction under section
If
326.
you get ready, you tell me so that I can.
My lord, my lord.
know,
Obliged.
I can hear early also. No problem.
My lord.
Whenever you are ready, you come with.
My
me.
lord.
Listen to weekly list.
104 is not likely to reach, but so let it be in the list, but can be taken up after 2 weeks. If there is
Yes, yes.
compromise, the land, I have given the
When-
offer to.
If you can come with your friend, then I
Yes,
can
yes,
take
I
it
was
to-
searching, he is not there.
Whenever you are coming,
Yes, yes.
I'll take it up.
Madam, obliged.
Lordship, on behalf of Mr. B.R. Dolai, item number 123, pay for an
123.
adjournment.
What do you want?
Adjournment, Lordship,
Adjournment, don't ask adjournment like this. 123.
123.
What is this matter? 2015 matter. Do you know what is this matter?
No,
No,
Lordship.
you get the file, read it and mention.
Lordship, we lost our.
No, you read it and mention. Then only I'll entertain you. Tomorrow you read it and come.
Lordship, 10 days time.
You read it and come. You must know what are you doing? Which matter you are mentioning.
They lost the file, my lord. That is in.
You lost the file. You collect it from here. Get the pen drive and collect it. Let it be there.
Obliged.
Yes,
Item 121.
yes.
Can I take 2 weeks after my?
2015 again. It will come after 2 weeks only. Don't worry.
2 weeks.
Let it be there. 2 weeks.
121.
It don't reach before 2 weeks. Yes. Senior counsel is there.
My lordship, 143, my lords.
Yes.
My lords, we have been trying to trace out the applicant over here. My lords, in fact, our file has also been misplaced.
Trace out whom?
The applicant over here, the petition, my lords. CRLA, my lords, item 143.
2004.
My lords, we understand it. My lords, there are two difficulties. One, we have lost the file so that we can take the file from here, this court. Two, and my lords, we have no instructions to that. My lords, we are trying to trace out who's the what is the whereabout of the petition. So if we pray that it may stay on hold,
You construct your file first, then you mention, we'll see.
my
Let
lords.
it be there, yes.
That's item 168.
Yes, sir.
I am not asking for time, but the question is the appellant having died, his legal heirs have filed an application to be substituted as appellants, but there is a delay. Item 168.
Delay of
Delay,
how many?
I am not 61 days delay. Your Lordship may condone that and
This is vigilance appeal?
Yes, my lord.
Condone the delay and allow the application.
Let them serve a copy also for our record, my lords.
Please serve a copy. I am condoning the delay and allowing the
yes,
application.
I have served, I will again serve.
Yes.
I will again serve.
Right on
What's
the
it?
application, the read that application.
There are two appeals.
There are two appeals. in
Similar
168.
sub-item, it is criminal appeal 454 of 2011.
No, the appellant
There
died
are
in
two appeals, my lords. There are two accused
Which
persons.
appellant died?
Nahin,
Second item 454 of 211, the appellant is dead and his legal heirs have applied to be
454, okay.
substituted.
Okay. Okay.
Kailash Chandra Rautre, perhaps.
Sub item is like
Yes, yes.
Sub item, right? The where is the death certificate?
Yes, we have not filed the death certificate, but in para 1 I have said
No, my lords,
the
let them
appellant,
file the death certificate.
Death certificate.
which is necessary when I am saying on oath, I will file if they
Para,
may
which paragraph?
para
Date
1. Because
date
the
of death
original
also you
appellant is
mentioned.
died on 17 2019.
But you have not
17 1
mentioned anywhere.
2019.
You have not mentioned anywhere.
Yes, in para 1 of the application, Miller, IA number 663 of 2019.
63.
663
Flag
2019 in para 1, I have where the legal heirs have applied to be substituted, I have mentioned it.
Okay, yes.
Flag C. my lords.
The sole appellant in the present case stated to have expired on 17/1/2019. Therefore, the present application is moved by the LRs for the sole appellant to continue.
Yes,
the appeal.
Miller.
Continue the appeal. The application is allowed. Huh? 663. 664. There is a delay. There is delay of
61 days, Miller. 61 days, Miller.
61 days in moving application for application.
For being implemented, Miller.
Under section 493, na? 494, na?
394 provision.
394.
No, criminal appeal 454.
Right. And
Yes, 394. Yes.
And the delay is condoned for the reasons taken in the application. This is the matter for final.
Well, that's my formal objection may kindly be noted.
And Mr. Rijvi objected to the application. However, in view of the reasons stated in the application, I am inclined to allow the application accordingly.
I think law permits. I don't think any objection is required. Law permits the substitution.
Condonation of delay in filing the application under 490, what is that section? Always 394 IPC, CRPC.
Obliged.
Item number 159. Paper adjournment, 1 week adjournment. Mr. Sobon Pranigai is not in.
It is in weekly list. It will not come before one week. Don't worry. Yes.
Please.
Let us come to the.
My pleasure, Chief. Item 138, my lord. Paper 2 weeks after 2001 matter, my
It will
lord.
not come. Don't worry.
Item 93. Item 93. Weekly item 93.
Yes.
2 weeks time.
It is there in the board. It will not come before 2 weeks. Wait. Yes. Miscellaneous matter 1.
My lord, item number 31 may be taken up after launch. 31.
Why?
Counsel is on the access.
Let it come. We will see. after one. Yes.
By pardon, my lord, one mention, my lord.
Yes.
On CRLMC.
CRLMC is not there in this court. Some other court.
Your lordship, last occasion, your lordship's oral.
Modification?
No. Plus.
It was there earlier, but not it is gone. Yes. Yes.
And for the opposite party state is filed the appeal for cancellation of bail, your lordship. So for my assumption, I have filed my reply to my
What is the ground?
That the learning state council has relied on a notification issued by the state government of Orissa, which is not applied in case of my case, your lordship. Because here is the petition.
Show me the
Yes, that is Annex 3, page 31, your lordship. That notification is annexed.
No.
Because that notification in respect of the Forest Act, your
I'm
lordship.
asking something. Show me the order
Yes, your lordship.
by which the bail is granted.
That is annexure.
Page 25.
Page 25.
Relevant person, my lord, page 28, my lord. 28.
Yes. Yes.
12th sentence, my lord, from top, my lord. Thus, the seizure of articles and arrest of accused petitions were affected in the contravention of Section 50 of the Wildlife Protection Act 1972. No such authorization or letter of order is available in this case record justifying the same. As per the Section 50 Wildlife Protection Act, the director of wildlife preservation or any other officer authorized by him in this behalf, or chief wild warden or the authorized officer or any forest officer or any police officer not below rank of sub-inspector empowered to enter into the place where the wildlife materials are suspected to be kept, conducted search for the wildlife materials, see the same, arrest and detain the accused on suspect. It is to be understood that all the action together constitute investigation within the legal framework of the Wildlife Protection Act 1972. What happened, my lord? Considering that the court below granted bail, my lord.
It says that
Since the forest guard is not competent to seize and arrest the accused, my lord.
Yes.
For my lord, can't see annexure 31.
Under wild
my
life
lord.
protection.
Page 31, my lord. Annexure 3, my lord.
Hmm.
In exercise of power conferred of subsection 2 of clause F of section 2 of Orissa Forest Act, 1972, hereinafter called Act, the state government do hereby notify all forest guards.
What he says that it is in the Forest Act, that's the Wildlife Act.
My lord. My lord, here, my lord.
Section 50.
My lord, Forest Act and Wildlife Protection, my same person is, my lord, since that has been, my lord, in the forest, my lord, they killed the elephant, my lord. Forest guard is competent to
Under Wildlife Act, where is there any notification? No.
No, madam.
That is what he says, that in the wildlife, this notification will not cover Wildlife Protection Act.
Madam, Wildlife Protection Act and so also the the Forest Act, my lord. This petition is competent, my lord.
Show me anything.
This is the, my lord, the Annex 3 Forest Guard.
No, that's under the Forest Act. Under Wildlife Act, is there any notification?
No, my lord.
But this will apply to the Wildlife Act also.
That wildlife, my lord. What happened in this case, my lord? Since that has the elephant killed inside near the forest, my lord, the forest guard is the competent, my lord, to investigate the case, my lord.
Forest guard, so far as the forest products are concerned.
My lord.
But in so far as Wildlife Act is concerned, it is a special statute. Whether is there any authorization under the special statute?
But the foresters and forest guards they are competent, my lord, to investigate the case, my lord.
Show me something.
But this is the one for that is the they have charged my lord. Final pay are submitted against him. They have not disputed that, my
You
lord.
are prosecuting him for under the
Wildlife Protection Act, my lord. The forest
and the court gives him bail because the guard was forest guard was not authorized.
No.
Under section 50 to
they stated that not the below rank of sub inspector, my lord.
That is under the Wildlife Act.
My lord. And also, my lord, he has stated that the warden also is competent, my lord. So the forest.
You show me some link between the Forest Act and
Wildlife Protection Act, my lord. But since, my lord, the entire the foresters are my lord, these forest officers are allowed to investigate the case and file submitted statute.
Otherwise,
under Wildlife Protection Act, my lord.
What are the sentences
prescribed?
Punishment prescribed?
Punishment prescribed, my lord.
For the alleged offences? What is the punishment prescribed?
May I read your lordship? 51 penalties. Any person who contravenes any provision of this act on Wildlife Protection Act, except chapter VA and section 38J or any rule or order made thereunder who commits a breach of any of the conditions of any license or permit granted under this act shall be guilty of an offense against this act. The shall on the conviction be punishable with imprisonment, a term of which may be extended to 3 years, or with fine which may be extended to 25,000
How
rupees,
many,
or with both.
how many months or days you were in custody?
Within 1 month, my lord.
1 month custody, he is already undergone. He is on bail.
Final PR was not submitted by the time, my lord.
He can, technical ground, you may be correct or may not be correct, while once bail is granted, why unnecessary? Madam, the present petition is filed against the order dated 23/3/2022, passed by the, which court? Passed by the Court of Sessions, District and Sessions at Burger in BA case number 54 of 2022, whereby the petitioner, the opposite party number 2 or opposite party, has been enlarged on bail. The state has filed the present petition in prelia seeking cancellation of bail on the ground that the sole ground for grant of bail to the opposite party is that is on technical ground, which is not sustainable in view of the notification dated 7 May 2005 under the Forest Act. The counsel for the opposite party submits that the notification is not covering the case in hand, because the prosecution is launched against him under the Wildlife Protection Act. However, Mr. Ragada says that since the act has, since the offense has taken place in the forest area, and the forest guard is competent under the act to seize
And arrest
any person. I am not inclined to go into all these questions at this stage, because this is a matter regarding cancellation of bail. The court has exercised its jurisdiction, extending concession of bail to the petitioner. Hence, I am not inclined to anything in this petition. I can read this. Yes. Yes.
Item 3.
Well, here, I filed a petition for substitution of the appellant who has died. Before that, Miller, can I pray that the file has been transferred to me?
Yes.
Can I pray that the names of the all other landed councils may be deleted? Because since they have transferred the file and ultimately I am the lawyer. So
Names of all the councils may be deleted.
Those who have appeared after me.
May be replaced by the name of.
My name is there. My name is there, but the names of all the previous councils may be deleted from the cause list or the.
Replaced by Mr. Himanshu Mishra. Yes. What is this matter is about, sir?
This matter, the appellant has died.
Yes.
I have filed a petition under section 394 for substitution of his legal heirs because this is appeal against the conviction. And this petition has been filed on 22/8/23 with a serving copy.
IA number?
IA number, my lord, this is 2013 of 2023.
2013. Am I allowing this?
Though the office note is there, copy is not served, copy is was served.
Only problem, my lord, is that
Sole appellant? Your sole appellant?
Sole appellant died.
This sole appellant
Died and
in the present case has died on
6/10/2020.
6/10/2022. Therefore, the legal representative of the sole appellant have filed the application under section 394 94(2) of CRPC to continue the appeal. In view of the reasons stated in the application, the same is allowed, and the sole appellant is substituted by the LRs of by the LRs. Amended memo parties will be filed within a week. Please the matter up. Here.
There is another application also for condonation of delay.
Delay for the
Yes.
reason stated, Mr. Rijvi opposed the application for condonation of delay in moving application under 394 to CRPC. However, for the reasons stated in the application, the same is allowed.
Great.
Yes.
Item 4.
Please,
The matter is of
And no, in item 3, there are 3 appeals, na?
Yes,
No,
my
no.
lord.
Yes.
Or the other, yes,
Which appeal you have,
first one,
first one, na?
410.
410,
Third.
list, okay. Yes,
My lord,
4. Yes,
the paper books is ready and I have already received it. Let the matter be listed in the hearing list. I will have it in the next.
sorry, I didn't follow you.
My lord,
I didn't follow you. What do you want?
in this case, paper book has already been supplied to us and let the matter be posted in the hearing list
This is,
in the
this
next
is,
week.
this is against conviction.
Yes, my lord.
Yes, sir.
Okay, so which year?
It is a year of 2007.
So, weekly, the
How'ble.
paper book, you got it? Paper book?
Yes, my lord.
Yes, yes. Paper book has already been.
The matter is ready for hearing. Since the paper book has already been supplied to the party, this is the matter for hearing.
Next week, my lord.
Yes.
Item 5.
Please, my lord. Today morning, I received an instruction from family members that the appellant has died.
Sorry?
The appellant has died, my lords, in the meantime. So kindly be taken up after a month. I will file a death certificate.
No, the death certificate is not required. Land Council, when he died,
2 days before.
Land Council for the appellant submits that the sole appellant
Yes, ma'am.
in the present case has died on
2 days before.
Huh?
2 days before.
2
ma'am.
days. Tell me, day.
On 29th, my lord.
29
June, my lord.
June 2021. So in view of thereof, the appeal stands abated. Yes.
Item 6.
Item,
Yes,
my lord,
yes,
item 6. My lord, I am in item 6, my lord. My lord, the petitioner is the wife of the deceased husband, filed the paper for granting leave to continue the appeal which was filed by the deceased husband.
I number?
IL number, my lord, 30000.
Okay. How many
I
days delay?
3000. My lord, he was deceased died on 3/12/2020, but it is filed on 8/12/2023 because due to corona.
Okay, it's all right. All right. 3080. IA number. The sole appellant stated to have expired on 2020. The wife of the appellant, deceased appellant, seek leave of this court to continue with the appeal. For the reasons stated in the application, the same is allowed. There is a next 3001. There is a delay in filing application under 394 CRPC. Mr. Rijvi proposed the application. However, for the reasons stated in the application, the same is allowed. Demanded memo parties shall be filed by the substituted appellant within a week. Please the matter for it. Yes.
These matters will be
Obliged,
tagged
ma'am.
with the weekly
Huh?
weekly list. This will be tagged.
It will go weekly.
Ma'am.
Yes.
Item 8.
Yes.
8, can I pray before Lordship?
Hmm.
Any day next week, I have to take instruction whether there is a dispute between brother and brother-in-law. 130.
2011 matter.
Huh.
Yeah, conviction against conviction.
Conviction. Right.
Yes.
Only to that extent.
Conviction under which provision?
138 Act.
And for the complainant,
That is the brother-in-law.
Check amount.
45,000.
45,000. That is, they have admitted, I have admitted 5,000. 16 भिणेको भित्र गण्डगोल. That has been
To
completed.
settle it.
हाँ.
They have to settle the
हाँ, मुझे settle
convicted.
करियो.
I send it to mediation.
Mediation नहीं सिर्फ ना instruction नहीं होता.
हम instruction नो जो settle up होगा भी better होता है.
45,000. Why unnecessary?
हाँ, 16 भिणे भितर गण्डगोल.
Unnecessary. It will create, harshness among them again. Friday? Friday.
Next week, any day next week. I'll take
Friday.
it.
Why?
Like,
Friday.
Huh.
Come on Friday. Friday.
can I pray? My friend may be also directed to cope with me.
What?
With the petitioner.
For settlement, there
For
can't be a
settlement.
direction.
ठीक ଅଛି.
Settlement is settlement. How can the court direct? Settle? Yes.
Item 10.
Yes. Then APS on behalf of- what is this? Who is appearing? This 138. 138. 138. ये नम APS. पास और करो अदरवाइज डिसमिस कर दो ठीक है हाँ क्या हुआ 138 हाँ ठीक है 138 का नो 138 स्टे तो नहीं nobody is coming for order
Item 11.
पास होगा
May I please, my lord?
yes
My lord, herein we are seeking to assail the order dated 5/3/2014, wherein the learned special judge Vigilance rejected the application filed by the petitioner under section 457 of the CRPC, my lord, for wherein he had prayed for release of bank passbook, checkbooks, ATM cards, and other items, my lord, seized from the possession of the petitioner by the vigilance authorities during the course of investigation, my lord. My lord, the FIR was lodged.
This case, my lord, I got the instruction on that to refresh your lordship memory. This is that case lordship wanted why charge sheet has been
The
filed.
charge sheet has not been filed.
I've got the instruction. It has been filed, my lords. But in the meantime, my lord, this revision, my lords, was placed before the registry, my lord. Registry indicated, lords, you can't see the notings in that cause title in the cause list, my lords. The stays for limitation not taken, my lords.
My lord,
In the absence of any limitation petition, my lords, being allowed, my lords, there
my
is
lord,
no.
limitation petition is there, my lord. You have filed it, my lord.
No, this is the noting, my lords.
forget about the technicality come to the substantive point what is this point what is the real issue
My lord,
forget small things
my lord, the investigation.
what is the reasoning of rejection
My lord, the reason of the rejection is, my lord, at page, my lord, page 17, my lord.
annexure
Annexure. My lord, extremely sorry, my lord, extremely sorry. It is not at page 17, it's at page 35, my lord. Annexure 3.
yes
Annexure 3, the operative portion, my lord, is at page 38, my lord.
38
38.
yes
Keeping the aforesaid proposition of ruling in view, I may say that in the instant case, learned defense counsel has not averred anything in his petition, nor he has put forth any argument to convince that the bank accounts and the documents in question have no direct link with the commission of the offense. Rather, from the investigation conducted so far, it is transpiring that the accused petitioner has accumulated assets, which is disproportionate to the extent of such and such of his known sources of income. In view of this, it is difficult at this stage to say that the seized bank passbooks and documents have no direct link with the alleged offense.
so it is at the stage when the charge sheet was not filed this was the order
My lord.
I'll set aside move fresh application
My lord.
because charge sheet is
My lord, as per my instruction, the charge sheet was not.
but
was
each
not
case charge sheet is filed
My lord, my
the
lord.
date
I have got
I'll
the
set aside this
I have got the copy of
because the court says express his opinion
My lord, my lord.
not to entertain your application at that stage. Now the stage has crossed. Now you in the fresh development, you can move application. I'll set aside and go and move application. Right now, when the charge sheet comes.
The charge sheet number 34, lords, dated 9/10/2023, lords.
9/10.
2023, lords.
23.
Right on.
May pass on the charge sheet the relevant pages.
Please. Right on. Okay.
That's a bulky charge sheet, 40 pages. I just give the first page.
Against the order dated 5/3/2014, whereby the application of the petitioner under section 457 CRPC for release of
Bank accounts.
various
Bank
documents
accounts.
pertaining to bank accounts
Bank.
had been turned down. The court below had turned down the application of the petitioner petitioner inter alia stating agent. It's like the book. In view of this, it is difficult at this stage, at this stage to say that the chief bank passbook and documents have no direct links with the LI's offense. Continue. Thus, in my considered view, the passbooks and other documents are the foundation of the assessment of DA, and therefore, I am not inclined to allow the petition under 457 CRPC when the investigation is in the progress. Further underline, in the region, the petition is the learned counsel for the petitioner submits that the investigating agency has not filed the charge sheet, even though the FIR was way back in 2013. Mr. Das, learned counsel for the petitioner, however, hands up the copy of the charge sheet, which indicates that the charge sheet has already been filed on 9/10/2023.
Charge sheet number also.
White charge sheet number 34. White charge sheet number 34 dated 9/10/2020. In view of the fact that the charge sheet has already been laid down and the application moved by the petitioner was turned down, pending the investigation. I am of the view that the petitioner should move press application before the court below under 457 CRPC for release of the passbook and the other related documents. In view thereof, the order dated 10/7/2024 is passed by the special judge Vigilance Cuttack is set aside.
My lord, the order date is 5/3/2014.
5/3/2014. Passed by the special judge Vigilance Cuttack is set aside with set aside. The revision petition is disposed of with liberty as well.
May I submit one thing, lords? The rest has indicated that limitation has not been taken up. My learned friend said at file, lordship, one line that delay condones, lordship, not regularize the matters.
This case number 175. Value.
Yes.
Item 12.
What is actually the appeal against the interim order of a confiscation proceeding? The appeal is now the infructuous on the ground the origin principal accused had died. The original case.
Learned counsel for the petition submits that the petition is infructuous in view of
I am doing petition on my lord.
petition is disposed of. Yes. Next.
13.
13 lords against order of cognizance.
The 2008 cognizance, last occasion I.
What is this date now?
Now, my lord, my
Already-
discharge
already
application
liquidated.
of, no, discharge application filed by the co-accused has been rejected. Against that, 482 is pending before this honorable court. So liberty may be granted to file a discharge application before the land trial court. And
This is a matter, this is a petition arising out of an order dated.
I have no objection.
Order dated 25/3/2008. Passed by Learned Special Judge Vigilance Bhubaneswar in TR case number 8/2008, whereby cognizance of offences had been taken against the petitioner.
Under section 13(2), 13(1)(e).
Under section 13(2) and 13(1)(d).
1E.
1E of prevention of
DA case.
corruption. Mr. Pradhan, learned counsel for the petitioner submits that one of the co-accused person had moved an application for discharge from the offence which has been turned down by the trial court, against which a revision is pending before this court. In view of the same, he seeks to withdraw this petition with the liberty to move appropriate application before the court below, seeking discharge. With this liberty, the petition is dismissed.
Mr. Tama, revision pending was 482 pending.
Pending 482
Another court has soon, it has soon.
They call a discharge, his application will also be dismissed, obviously.
No,
They'll file and get back with that.
again discharge application rejected and 3 jaka set aside. This is the 4th application pending.
Good.
Item 15.
Your lordship.
Yes, sir.
Has been convicted under section 357 and 457 and 380. 457 and 380. And faced 380. And faced trial before the Lord and SDGM. And Lord and SDGM convicted him for 2 years under section 457 and 3 years for 380. Subsequently, preferred appeal. It was partly allowed and the sentence modified to 1 year each. 1 year for 457.
Undergone? How much?
Undergone, my lord, near about 3 months.
Incident of which year?
2007 year.
2007.
Yes, sir. Tell me.
From inside custody, since what I have got from information, 21/4/2011 18/7/2011 ଥିଲା.
Undergone. 3 months undergone. Offense under section 380.
457 and 380.
457, 380. 1 year sentence. What do you say? Do you say something? Otherwise, I know what to do and you have to tell. I'm waiting for that. That should come from you.
Because it is seizure list, everything has been proved.
Everything, I'm not interfering in conviction.
Yes.
I'm talking about the sentence. Like probation. Probation, 3 months already undergone, 1 year sentence. Why should you send 2007 incident? Sending him to jail today makes no sense.
And no antecedent, your lordship.
Antecedent is also not there. What do you say?
Yes, sir.
You are opposing or not? You say yes or no?
Definitely we are opposing. We
You
cannot
tell
say.
me oppose it, then tell me the grounds and all.
Which for the society it will be there.
If you object, then we will have to deal with that.
In society it will be wrong, message will go.
That is the general statement. Society is like that. Nowadays, nowadays you don't get thief also. You get only internet cheating. And theft and all is a very difficult task nowadays.
I mean, now perhaps he is more than 60.
He is.
At that time,
2011, he was 35.
35.
So now
45 above.
Yes. Show me what is the evidence.
Evidence is of PW3, your lordship. PW3 is the eyewitness.
No, he wants to oppose Hadasi. PW2 and 3.
3 is the eyewitness.
The person of the her village. They know. And he was calling, she was calling him. At the time, he ran away. And 20,000 was a record from his house. Page 8 and page 9 order civil orders.
And he has, in the trial court also, he has prayed for the provision, which was turned down.
Yes,
But except to the 20,000 rupees, nothing is recovered. But the gold necklace and silver, this thing, one gold finger ring, a torchlight, and everything was stolen. Your neighbors or what?
Neighbors, ତାଙ୍କ ପାଖ ଗାଁ ଲୋକ ବୋଲି ସେ କହୁଛି PW3.
PW3 is
They know each other.
Previously, they she know that.
in that village. The informant wife was the accused of the informant's wife's house, village. She knew. He called that person at the, he recognized him, he ran away.
Kali 20,000 recovery is 20,000 taku usually cash was with everybody. How can they say that cash belongs to her?
That
cash taku ସେମାନେ ତ କେବେ TI period କି object ଭାବରେ establish କରିନାହାନ୍ତି। ଆଉ ମୋର 27 evidence act ବି ନାହିଁ ଯେ ମୁଁ recovery ଦେଲି ବୋଲି ସେଟା। But with that is my lordship, near about 17 years have passed. 2007 no matter.
In the trial court also, he has prayed for benefit of probation of 400,
Yeah.
which was declined. And you just, you tell me the undergone period.
Well, I just checked up the LCR lordship and
you written that.
ମତେ ସେ ଲେଖିଛନ୍ତି ଯେ 24/4 ରୁ 18/7 ରେ ପର୍ଯ୍ୟନ୍ତ ଥିଲା। 24/4/2007 ରୁ 18/7/2011 ରେ ରିଲିଜ।
2007
ଆଜ୍ଞା
arrest ha
ଆଜ୍ଞା
ଆଉ ବେଲ୍
ଟା ହେଇଛି 18/7 ଜଷ୍ଟ ମାନେ କହିଛନ୍ତି ସେଟା ଠିକ କହିଛନ୍ତି କି ଭୁଲ କହିଛନ୍ତି
ଚେକ୍ କରିକି ଆର କୋର୍ଟ ଲଗେଇ
ଆଜ୍ଞା
okay provision conviction maintaining provision slip would लिखी देते हैं yes
item 16
चलो
My lord, this case I appearing today. This is the transfer brief. I received today the file. So this matter may be taken up on 2 weeks after.
Not may submit one.
what is this matter
It's against an conviction. Say against an order of conforming judgment, my lords, confirming the conviction under section 468, 471 IPC, my lord. In this case, well, on the basis of the concorded documents from Ranchi universities, the petitioner in this case, my lord, was appointed as a science teacher in high school, my lords. The Ranchi University staff was examined as PW7, and PW stated in the findings is that the PW stated, even after his retirement as a section officer of the concerned section of the Ranchi University, has boldly stated that the accused was not at all a student of Ranchi University, and the document exhibit 1 to 4 were not issued by the university authority, but are fake and false too. The evidence of PW received corroboration.
My lord, today morning I received.
okay I'll put it next week
No, 2 weeks after, my lord.
there is nothing in this
The
matter
thing will
You
not
think
improve,
of
sir.
how many days you have undergone
Okay, my lord.
undergone
It's 1 minute. To conviction, fine 2,000.
And sentence?
One minute, please. Mhm,
3 years.
Sorry.
3 years by the trial court.
The conviction
And
is
appellate court, what does?
for 3 years, my lordship, correct, lords. The convict is sentenced to arrive for 3 years and fine, lords. Fine of 2,000 rupees.
3 years sentence. Okay,
My lord,
Vokalatna.
Bhina.
Release the matter.
my lord, 2 weeks time.
2012 matter. Okay.
One.
2 weeks. Yes.
Quick. Oblige, my lord.
Sub 17.
17, my lord.
Like 17 and 20.
Yes, ma'am. 27, 17 kind of disposed of books.
17.
Yes,
What is this matter is about?
My lord, in fact, lordship turned to the annexure 1. The Lord and PP at Belangir, my lords, filed an application, lords. In fact, to take one statements recorded on section 161 CRPC to the records, as the statements could not be inserted during the filing of charge sheet. Lords, we can turn to page 11, lords. That application is allowed. Challenging that thing, lords.
The annexure, set aside annexure 3, na?
The annexure 1 is the petition. My lord, that will clarify the position. This particular petition filed by the special prosecutor Balangir with a prayer to accept the statements recorded under 161 statement to the records, because these statements could not be inserted in the charge sheet. So that was that having been allowed, my lords, that their application was allowed. Annexure 3, my lords, impugn order has come up, my lords. That and against annexure 3, my lords, he has preferred this revision. If lords, you can see that place 11 that clarify the position.
Challenging the order dated 3/11/2011, whereby the application of the prosecution to insert
Correct.
the statement of one of the witness, namely
Which could not be inserted inadvertently in charge sheet.
Benjamin Nag under section 161 CRPC could not be inserted with the charge sheet. The application, the application of the prosecution was allowed. The petitioner being the accused was agreed, therefore approached this court.
In the year 2012, lords.
Yes, trial has already been progressed substantially. Mr. Himanshu Mishra and counsel for the petitioner submits that he has no instruction in the matter. Instruction in the matter in view of the aforementioned, the petition is dismissed. Yes. 17. Next 21 ले दो. When he has mentioned 21 also.
Yes, ma'am.
21 में क्या है?
This is also an application, my lords, calling in question the legality of an orders by which the charge has been framed, lords. Charge has been framed at page 14, my lords.
Page 14. It's challenging the order dated.
Order dated, in fact, 25/2/2016, lords.
Rising out of an order dated 25/2/2016, passed by the Special Judge Vigilance in CTR case number 13 of 2012, whereby the court has framed the charges against the petition. The present petition is pending since 2016. There was no stay operating.
No. Entry mode was there. Entry mode
was operating.
Entry mode was there.
Then the trial must not be proceeding.
I have no instruction, but your lordship can turn to 4/4/2016. That's the entry mode is there. It's no instruction.
That he has no instruction in the present case. In view of the long pendency of the matter, I am not inclined to entertain the same on the same papers. Yes, auto.
Item 20.
Let's, item 21 also disposed.
21 is.
Wait, your Lord's ballot. Here, ballot, the petitioner has been convicted for the offense under section 436, 451 and 427 of the Indian Penal Code, and measure sentence is 5 years for the offense under section 436 and to pay a fine of rupees 5,000 ballot. Here, ballot, it is alleged that when the inmates of the house were sleeping, the petitioner came and set fire to the motorcycles that was in the near the door, my lord. And that caught fire to the 2 rooms adjacent to the same. My lord, on a perusal of the evidence on record, my lord will see all the witnesses are, my lord, witnesses, they have not seen the occurrence. They have heard it from PW5.
Yes.
PW5, my lord may see the evidence of PW5.
PW5.
Who is, yes, Benudhara Aruk. Got it? I know the accused. The informant is my son. Informant is PW4.
PW?
My lord, PW.
PW5, huh?
My lord. He has stated in the night the accused came and set fire to the motorcycles which were kept inside our house. Both the motorcycles were burnt along with our house. I told the family members about the burning of motorcycles and house. The villagers put out the fire. I lost my son. My lord, the evidence is also forthcoming to the effect that after the alleged burning, the petitioner also came along with other villagers to put out the fire, my lord. And admittedly, they had enmity with regards to the marriage of the, my lord, daughter of PW5. But it is alleged that there was marriage proposal of my daughter, who is the nephew of Solar House, and the accused is working under Solar House. Said marriage proposal failed. I don't have good relationship with the accused. After the failure of the marriage proposal, we thought that Lambu caused the failure of the proposal. Lambu is the relation, my lord, cousin. House is in the backyard. And my lord, seizure list shows also seizure of 2 born motorcycles, half-born motorcycles. Nothing, no household, nothing, not a single person of the house has received any injury or any household articles have been seized or have been burnt. Nothing is there. 2 motorcycles which were on the passage that has been burned. It is alleged.
Dwelling in it.
My lord?
Dwelling in it. Unit.
My lord?
Unit is a house, basically. Right?
Yes, that was in the passage. Motorcycles were in the passage. My lord, he has also stated, my lord, IO has stated, BW5, Benudhara Aruk has not stated before me that the accused set fire to the motorcycle with a matchstick. Nothing. That he has not stated, that the IO says, paragraph 7. And it's a case of 2010. In between, my lord, 15 years have been passed. While I was verifying, my lord, that he was in custody for around 7-8 months. My lord may enhance the fine and sentence the period order. I think that will be.
This is a conviction under 336, na?
436. It can be 435, my lord, because if my lord will consider that intention was to set fire to the motorcycles, which is not a household, my lord, then it can be 435. Huh?
How 435, how you bring it up 435?
435 is not how that deals with
Whoever commits a mischief by fire or any
Up to-
explosive substance
Huh.
intending to cause or knowing it to likely to
if it is not a dwelling house ballot, it can be
any
430.
property to an amount of 100 rupees or upwards.
That is not prosecution case that it is something serious damage has been caused.
There are
And
two
if my lord will
two motorcycles were burned.
have bought my lord motorcycles, then we must have got the insurance and everything. And conviction, if shall be punished imprisonment with which may extend to 7 years. And in the case of 436, it can be
10 years.
maximum 10
Life
years.
imprisonment also.
That depending upon the gravity of the case, right? Custody of the property, my lord, is the building which is originally used as a place of worship or a human dwelling. That place which was bought, my lord, it is not a human dwelling. It was kept, motorcycles were kept there. By way process of getting fire there in the motorcycle, the fast house, because investigating officer has said.
Are you trying to say that you set fire the motorcycle?
But, my lord, but that is the case. My lord may see the
So
evidence
if
of
you
the.
set fire to the motorcycle, not the house, then we can bring to 335.
435.
Oh, sorry, 435.
My lord, may kindly
Show
see.
me any
Because the IO has said, PW 8 has said, PW paragraph 3, I left in Jima of the bond motorcycles and its documents in favor of.
No, you set fire to the motorcycle. You show me that. Eventually.
Yes, my lord, PW 5, PW 5, my lord. The person who was alleged to have seen the occurrence.
Then you may.
In the night, the accused came.
5. Okay.
My lord, may got it?
Let us, yes.
My lord, got it?
Yes.
Second night. In the night, the accused came and set fire to the motorcycle which were kept inside our house.
Yes, sir. It was. Motorcycle was set fire.
I am placing, my lord.
436 house.
Yes, I am
Eventually, suppose motorcycle is set fire, eventually the house is burned. Then intention was only to burn the motorcycle.
Yes, that
so
I
he is out of 436.
That will be clear from the evidence of PW for informant. Just
You come out.
two lines.
Yes. PW?
4 informant.
Okay.
I know the accused and the informant in this case. At about 2 AM night, my lord, we have purchased one motorcycle, Splendor Plus. Another motorcycle was kept, which belongs to my brother-in-law. Both the motorcycle were kept in a passage connecting our main door, my lord, of the house. The passage is within the house, my lord.
No.
Yes, passage is within the house. Yes. My father raised Halla stating that.
Come to 4. Come to 4. Cross-examination. It is very clear. My father raised.
It is in fact that I have not stated.
My father raised Halla stating
You read that paragraph. That
Lambu set fire to the by mistake there.
And read it further.
Yes, ma'am.
Set the vehicle on fire by matchstick. Could not control the fire.
My father
the house got fire.
Lambu set the vehicle on fire.
The cross-examination 4.
By matchstick. We could no control the fire. The house got fire and
Thereafter.
The house got fire.
Yes.
And the house and motorcycle were burnt.
Obviously, that was the case.
Yes.
See, he has burned the motorcycle.
Ajela's house.
Eventually, it could not be controlled. Therefore, the house is also got fire. So, in that facts, admitted facts, where 436 is attracted.
Yes.
Read it.
Any building which is ordinarily used as a place of worship or as a human dwelling or as a place for the custody of the property, my lord. 430 language is very clear, my lord.
Come to 436.
Yes.
Whoever commits mischief by fire or any explosive substances, intending to cause or knowing it to likely to cause, that he will intending to cause. What was the intention? Intention is to burn the motorcycle. Okay. Likely that he will thereby cause destruction of any building and which ordinarily used in the place of worship or a human dwelling or as a place of custody of the property and shall be punishable with imprisonment of life. Human dwelling, anything you can get it from here? Was it a human dwelling?
Custody of any building, which is building.
In the cross examination, PW4 says, my bedroom is in the other side of the wall. And it
All the
was,
witnesses
I
have
was
stated in that way.
asleep in my bedroom. And I have not seen the who set the vehicle on fire. It's not even human dwelling. In the cross examination, you have extracted this.
Paragraph 3.
You have extracted this in the cross examination. How to get out of it? He says that I was sleeping in the adjacent house. It is not a house where he was
Dwelling house.
Dwelling house. Human dwelling house. And he very specifically says that when the vehicle was set fire. So converted to 336, 35. No, just you do. I think if you can develop it to sustain 346, say 436 on the face of this evidence. He has already undergone how much you said?
My lord, 493/2010 to 24/5/2010.
2010 to
24/5/2010
24/5/2010
and 4/11/2011 to 7/12. Reverse.
Yes.
On the road, sir.
Yes, sir.
Hello.
This is evidence I have.
This
placed
is
before
that
my lord.
we are finding out some way out to give him relief.
Lordship,
Lawyer defending.
10,000 minutes.
10,000 beta motorcycle.
Again, I said commensurate to the status of the counsel defending.
So, my lord, let it be 20,000.
Yes. 25,000 something. Right.
मिलो.
अभी इमीडिएट भूल जाऊंगा ठीक है PW 1 minute PW 4 and 5
4 and 5.
Yes. Yes, then
It should be from Monday to Friday.
Weekly release is every day.
Weekly means always it is writing from Monday to
High place.
Friday. Here only Monday is there. So
Monday
Tuesday anyone will not come.
That caption can be included.
Today is Monday, no problem.
Yes, my lords.
And for tomorrow it will be corrected.
Yes, in supplementary it may be in supplementary that can be mentioned, my lords. That weekly list will be taken. Yes.
Yes.
Beg pardon, my lord. Item 51, I pray for adjournment.
Let it be there. It will be
Adjournment.
obviously. Don't worry about the dates. If
Because
anybody
after
is ready,
difficulty,
come and let us do it. And old matters, I am not going to adjourn. Very old matters, we will hear and finish up.
Today I have some difficulty, therefore, lots of
No problem. Let it be there. No problem.
Item
Yes.
Item 26, my lord. Yes, small
20?
matter. 26, my lord.
Yes,
Small matter, my lord. Can it be here taken?
26, what did
Revision matter, my lord. Conviction matter, my lord.
Immediately after lunch, I will hear you.
Yes.
Yes. And appeal that will be heard first, huh?
My lord, noting is there, my lord.
Appeal.
Noting.
After 120, after 21, 126 to 180 should be taken up. That is noting, my lord.
Whoever ready small matters, we can.
Yes,
Yes, my lord.
I have two matters.
Sir.
Can it reports be called for with regard to their present whereabouts?
Item?
131 and 140.
131. 131, देखो तो. 141.
It's 94 matter, my lord.
94, na? Then
Yes,
you have to ask for 131, na?
148.
130?
1 or 148. In fact, 131, the original appellant has been substituted by legal heirs. But even those people I am not in contact.
Then they must be young.
Yes, my lord.
Well, they were middle-aged by then. This man was old by the time he got
The same order.
Yes, my lord.
Same order.
I will.
The SP, which area?
It will be probably.
You tell, or you give the.
Yes, ma'am.
I'll inform.
We'll seek instruction
I'll
from the
inform
SP of that. Local
Concerned division.
Vigilance. Yes. Sir, Radhika Petra karo. Yes.
131 and
140.
148.
148. 130 and 148. Upon take देखी कह देवे.
My lords.
Go area direction.
Mu dei devi.
Thank you. Yes. 29 may be taken up. No, it will be taken up. I am not ready. I am not ready.
Item 23, there is a three matters. So let's say kindly next week may be taken up. 23 matters are revisions and the criminal appeal.
Let it come, you request.
After recess.
No problem.
One is on the section 394 and the section 5 of the Limitation Act. My lord wanted to know as to whether. Yes. My lord wanted to know as to whether there is any chance of success in the appeal or not, otherwise unnecessary delay will be condoned. This is the entire aim to fix the matter today.
Right.
If you lordship will only one evidence, that is the PW2. This is overhearing witness. Only I will place the evidence of PW2. Yes, who is an overhearing witness. If you lordship will see the cross-examination part of PW2. He has not been declared as hostile.
Okay.
He has not been declared as hostile. Evidence of PW2, kindly will have a glance.
Yes.
Then only I will go further. Cross-examination part. I think.
Cross-examination is.
A 10th line below. Starts from
Para 2.
No demonstration.
Para 2.
Yes, madam.
Yes.
Yes.
No demonstration. Got it? 10th line below. Starts from no demonstration was made at Lanjigot Block Office.
Yes.
By Vigilance Police Officer. The detection was conducted at about 6:30 p.m. It was already evening by that time. The accused, but this is more important, The accused refused to sign the detection report prepared by the Inspector of Vigilance. The accused towards the close of the detection had protested, saying that Advocate Sahani forcibly gave him the tented money to organize a feast in the block office, but he did not demand any bribe from him. My lord, got it? By the time accused making such statement, the detection report is already over.
He gave it for feast.
Sorry, my lord, this is sorry, I am placing para PW 3, my lord. Sorry, exact. Sorry, my lord. Sorry, sorry.
PW2.
PW 2, page 38. Sorry.
Yes.
I was placing para.
38, I am there. In
Yes, sir. Place page 38. The cross examination para 2
Yes.
starts from the head clerk of Lanjigarh block office.
The head clerk, Lanjigarh post office.
Yes. Chair, a video of the block and one clerk of the office are present at that time. In that
room.
I do not remember if the sky was clouded at that time. Mr. Sahani means Malad Devkai, PW1, told the accused that the weather was very good and he wanted to have a feast with chicken. Malad got it?
Yes.
The accused refused to arrange a feast. The complainant for force put the number of 50 rupees note in the hand of the accused. I had not seen where the accused put the money after giving the
This
signal
is
of
which year?
the
90?
Hello?
4 minutes.
94.
Appeal of 94.
Party for 100 rupees. Party.
Yes. So if the evidence has come, PW2 overhearing witness has not been declared hostile and it is not a demand, not a gratification. The PW1 forcibly gave 2 GC notes. But what is the question of demand of gratification and payment of gratification and acceptance of gratification?
Leaving this evidence apart, what are the other?
If my lord PW2, if you will also kindly see the PW1 himself, PW1. PW1 evidence cannot be considered on 2 grounds. So lordship will see the evidence of PW1.
Yes.
PW1 in cross-examination, that your lordship will find.
Page 31 months.
I'm there. Page 31, I am there.
Para 2.
The paper will go cheap.
Yes. That my lord will find page 35.
Yes. Wherever the paper will give it, I am missing the writing.
Page 35, well, internal page 7 of the PW1 cross-examination.
30?
35, my lord.
30.
Internal page 7 of the PW1 evidence, my lord, can you see?
Yes.
Starts from a 9th line from the top. Starts from, I have omitted to state in the affair. My lord, got it?
1 minute. PW.
9th line.
No, PW1, na?
Yes.
Page 35.
Page 35.
PW1, PW1. Yes.
I have omitted to state in the affair and before the IO. In the month of November at Bhavan Patna, I have paid rupees 50 to the accused towards illegal gratification.
You read from the top.
Yes.
Right from the
9th line, starts from 9th line top, from the top. I have omitted to state, starts from.
Yes, I have omitted.
Yes, I have omitted to state in the affair and before the IO, in the month of November at Bhavan Patna, I have paid rupees 50 to the accused towards illegal gratification.
Okay.
Next, my lord, it is a fact that I have stated before the IO that on 6/12/89, I had paid rupees 50 to the accused. The statement of paying rupees 50 to the accused in November at Bhavani Patna is true.
Okay.
But which part is correct, which part is false? If the PW1 is not a solitary witness and evidence of PW2 has not been declared hostile, this is admitted case, so there is no bribe, no gratification, no demand. What more, lords, in a trap case?
The fact of the payment of 50 rupees to him in 1989 at Lanjigarh block office is also true, and it is not a fact that he did not have.
And these are all relating to prior demands.
How will you get our PW2?
PW2 should have been declared hostile, he has not been declared.
Then
hostile.
how will you discard that evidence?
Well, apart from that,
Is it not enough that PW2 evidence is creating a doubt in the prosecution?
so it's independent. PW2's evidence has been has been roped in only to see the
Whatever,
demand and
if
accept.
it is inconvenient to you, doesn't mean that you will throw it. How the trial court and appellate court has dealt with PW2? You can't, you lead your own evidence.
Yes.
Whichever is convenient to you, you rely. Whichever is not convenient to you, you cannot throw it. It has some relevancy unless you declare it hostile.
Yes, that has not been done.
So
That
then how
could have
will you
been
get
done.
over it?
But apart from that, also, Manoj, the other circumstantial evidence are pointing fingers at the accused.
What are
Your
the
Lordship may kindly come to evidence of PW1, page 29, man. 29 onwards.
Yes.
Page 29, the last fourth line, Manoj.
Hmm.
They had authorized me to get the TDS certificate from the block. Your Lordship got it, man.
They had authorized
Me to get the TDS certificate from the block. Manoj, this entire bribe money was given to facilitate the TDS certificate to be obtained from the accused. Accused happens to be the junior clerk, my lords, in the office of BDO Lanjiga. So he has been given the bribe money to issue the TDS certificates. That is the cash, my lord. The consideration amount has been paid to get the TDS certificates. My lordship may kindly see the next line. I approached the accused many times to get the certificates after obtaining the orders from the BDO Lanjigar block. The accused demanded ₹25 as illegal gratification for each TDS certificates. Here is the demand part.
Then he demanded 50 rupees.
25 rupees, rupees 25 for each TDS certificate. There were 4 TDS certificates to be given by the accused.
Where is that? Where is that?
Lordship may kindly come to the same page, my lords. Let me start from the beginning. I am an advocate, Bhavani Patna. I know the accused in the dock. Once during the month of September 1989, 5 contractors engaged me to obtain TDS certificates from Lanjigar block office. But here is the fact. 5 contractors. The accused was the clerk in charge of Lanjigar block office to issue the certificates under the seal and signature of the BDO. I know the handwriting and signature of the 5 contractors: Lakshman Kumar Nayak, Pradeep Kumar Boidar, Sudarshan Raut, Deepak Kumar Mohapatra, and Vijay Kumar Padi. These are their applications marked Exhibit 1 to 1/4. 5 applications, 25 each, my lords. These are their
BDO is supposed to issue.
My lords, BDO, it has to be put before the BDO. He will scrutinize and give his signature, then has to be given by the accused. These are the signatures marked Exhibit 1/5 to 1/9. They had authorized me to get the TDS certificates from the block. I approached the accused many a time to get the certificates after obtaining the orders from the BDO Lanjigar block. The accused demanded ₹25 as illegal gratification for each TDS certificate.
Really? Once in the
month of November 1989, I paid him ₹50. I agreed to pay the balance of ₹100 to the accused in December next. Since the accused repeatedly made the demands of the balance without issuing the TDS certificates, I felt offended and carried the information to the Vigilance Inspector Bhavani Patna. This is my FIR marked Exhibit 2, and this is my signature marked Exhibit 2/1. The Vigilance Inspector appointed a date for me to arrange the trap against the accused. I remained myself present at Bhavani Patna PWD IB, where the
when the trap taken place?
Trap has taken place, my lords, on 13/12/89.
13/12/89.
Present at Bhavani Patna PWD IB, where the vigilance officers were available. One clerk of settlement office Bhavani Patna and the accountant of DI office Bhavani Patna.
You say 20. Demand was 25 rupees per certificate.
Yes.
There are 4 certificates.
Yes.
Why you are supposed to? You have paid 150. 50 rupees you have paid in 89. November. Again 100 rupees. It will become 150 rupees.
There is 4 certificates, my lords. 5 certificates.
Justify that 100 rupees. You say 4 certificates.
No, no, 5 certificates.
5 certificates.
5 certificates, because there were 5 contractors.
5 certificate, each certificate 25, so comes to 125.
So 50 rupees you, November you have already paid.
Yes.
Still you are demanding 100 rupees.
No, as per
We
the
paid in
statement-
December.
As per the
Yes.
cross examination, he has paid 100 rupees. Twice he has paid 50, twice he has paid. So balance is only 25. If
Yes.
the cross examination part will be considered as,
Hmm.
so twice he has paid 50, but that has not been in the FIR, not
So
in
in
the
the
chief
context, in the
examination.
context of PW2, if you see 100 rupees justified because for
Yes,
party,
250,
there's
yes,
50
yes,
rupees.
yes, that part.
But that is in the light of the statement of PW2, now you see what was the demand, what was paid.
Correct. Correct.
What was the demand was? How much? 125 according to you.
125.
125. 50 you had already paid.
Yes.
Still he says that give me 100. Perhaps that is the reason you PW2 says that 200 rupees is paid for the purpose of party to be organized.
No, PW doesn't state about that.
PW2 says, oh, for party, the climate is very good. Give a party. He said, no, I'll not give a party. Then 100 rupees was paid. He was ABDO, no BDO.
No, he was junior clerk.
Junior
clerk.
right.
In the office of BD.
Right. And you show me the contractors. You are the PW1
Is the decoy, my lord, the complainant.
complainant.
My
Okay.
lord,
He is a lawyer. He is a lawyer.
Yes,
Yes,
he's a lawyer.
He says that I have been authorized by the
Contractor. Yes.
Show me the evidence of contractor.
PW4, my lord.
No,
page
none of the
44.
contractors have been examined.
Contractors.
No, no,
that-
he had, contractor has been examined.
No, none of the contractors whom he has been appointed not has been examined. You will also get PW4 is Prafulla Kumar Rao. Name PW4 is the one of the contractor my learned friend said.
No, 5 contractors' names are given.
Yes, names are there.
Names have been given.
Names
my
are
lord.
there.
Have you examined them?
Yes. Those, they have not been examined.
Yes, that I am saying.
Who is he to collect? How have you proved that they have authorized this lawyer?
My lords can see page 44, he is one of the contractors, but not the present contractors out of the 5 contractors.
This was obligatory on your part. When PW1 comes, say, he is the informant,
Yes.
he is the complainant. He says that X, Y, Z, 3 of them have authorized me to collect a TDS certificate. Unless you prove X, Y, Z, yes, we have authorized, or one of them, yes, I have authorized this lawyer. Without Vokalatnama, you argue a case. Kind of a situation. You have not examined either of this Lakshman Kumar Naik, Pradeep Kumar Bohidar, Sudarshan Rao, or Deepak Kumar Mahapatra, and Vijay Kumar Patil.
But my lord,
Those who are supposed to have authorized you being a lawyer to collect the TDS certificate from the BDO office.
but once another contractor has been examined, your lordship may kindly peruse his deposition, page 44. Page 44 of the paper book, PW4.
PW? Oh, okay. Yes. This is, he is
He is not Prafulla Kumar Rao.
Prafulla Kumar.
Page 44 of the paper book, my lord.
Yes.
PW4.
What does he say?
I just place it, my lord.
Yes.
Lordship have it, my lord, page
Yes,
44.
yes. What?
44, my lord.
44. Prafulla Kumar Rao.
Yes. I was a petty contractor under Lanjigar block in the year 1985. Lanjigar block office is located at Biswanathpur. I know the accused in the dock who was the cashier of Lanjigar block office those days. He was demanding 2% money on our bills. To get deduction of income tax, we used to get certificate from the block office. The accused was demanding 15% of the amount of the deduction towards our income tax. Then was the cross. I executed 4 to 5 contract works.
Who was demanding 2% of money of
Whereas this present
a
accused.
bill?
Yes.
And TDS amount 15%. Okay.
Yes. Then was the cross.
I executed 4 to 5 contract works under Lanjigar block.
Yes, I executed 4 to 5 contract works under Lanjigar block. For all those works, the accused was deducting 2% of the amount of my bills. Once I drew attention of the BDO against such illegal deduction from our bills, I had also reported this to Advocate Kumudu Chandra Sahani, Bhavani Patna. Such report was made 5 to 7 days after the amount from my bills was
Yeah,
deducted.
Kumud Chandra Sahani is the
Decoy.
I had also reported on this to Kumud Chandra Sahani.
To Kumudu Chandra Sahani, Bhavani Patna. Such report was made 5 to 7 days after the amount from my bills was deducted. Then my lord, I had discussion about it with my co-contractors. I did not report it to the police or any other higher authority of the BDO Lanjigarh. 1.5 years before starting work as contractor, I knew Advocate C. Shahani. Then Advocate C. Shahani was serving as a teacher at Lanjigarh. I did not know him. In the year 1989, I first reported illegal deduction of her bills by the accused to C. Shahani Advocate Bhavani Patna. I do not remember the year when for last I was paid my bill for my contract work from Lanjigarh Block Office. It is not a fact that I submitted and received no bill payments from Lanjigarh Block Office in the year 1987 and 89. It is not a fact that at the instance of Advocate Shri Shahani, I deposed falsely about the alleged deduction of 2% with the accused from our bill amounts. I do not remember the money on the year 1989 when I first knew to Advocate Shri Shahani. I contacted some of my co-contractors who advised me to contact Advocate Shri Shahani of Bhavani Patna in this connection.
Yes.
Then your lordship may kindly see from where the money was recovered, man.
Is convicted for which offense?
No, sir.
7.
7, my lords.
Only 7.
7 and 13 1D.
13 1D.
Yes.
Yes.
Lords may kindly come to the page 31, my lords.
31.
The day of incident and the deposition of PW1, the decoy.
Yes.
Page 31.
Yes.
Then we proceeded. Your lordship got it?
Then we proceeded.
Yes, ma'am. Yes. Then we proceeded to Block Office Lanjigarh. The raiding party remained outside. I and the witness proceeded to the office of BDO Lanjigarh. At my side, the accused wrote something and I passed him the GC notes in question. When the accused asked me whether I had brought the balance money, I handed over the GC notes to him. This is the demand part on the day of trap and detection. The witness gave signal and immediately the raiding party entered the office. The accused kept the GC notes in the drawer of his table. I was standing near the table of the accused. The vigilance officer caught hold the hands of the accused by hand. They asked him where he had kept the money. The accused reported that he had kept the cash in his drawer. His hands were dipped in the plain water. The plain water turned to pink color. Chemical wash was positive, my lords. Then, my lords, kindly come in the cross-examination part. Page 32. 32, my lords. Internal page 4.
Yes.
The sentence beginning at the first instance.
Yeah, the first instance.
Yes. At the first instance in the month of November, the accused made the demand. The said day I paid him ₹50 at Bhavani Patna in main branch of State Bank of India. It was not an appointed date.
I am wondering how demand is made to the lawyer. What was the occasion for the accused to demand the money from the lawyer? Did the accused knew that he is authorized? Whose TDS certificate?
Contractor.
Contract.
Yes.
I can understand if he demand the contractor. You pay the money, you take it. I can understand. How do the accused know that these 5 contractors have authorized some lawyer? So therefore he goes to the lawyer and asks money. How will you justify unless the knowledge imputed from the record that he knew the fact that it is the lawyer who is handling their cases? What was the occasion for these accused to go to this lawyer to ask and demand? How will you justify it?
Well, those contractors should have been examined. They have not been examined. That is
Who is
the
lawyer?
difficulty.
Yeah, who is lawyer? He is assuming all the powers. And you have read one contractor, he goes and give complaint to him. He is a police officer or who is he? He was a teacher, thereafter started practicing.
Yes, sir.
And is running a parallel administration. Any contractor, any problem, come to me. What kind of story you are putting forth? Demand to just Mr. Pradhan, demand to a stranger. Demand made to a stranger. He is a stranger to the prosecution.
Correct.
The
As
lawyer
per
is
the- as
a-
per the prosecution evidence.
Yes, that's what I'm saying.
As per
As per their own story, the lawyer is a stranger. If the demand is made to a stranger who has nothing to do with this certificate, TDA certificate, whatever, what will be the consequence? 7, read 7 only. 7, let us see. The story can't be believed, sir. You have to establish a link. Some sentence somewhere you find out. I was authorized by them and it was known to, unless the accused knows that a demand has to be made to a right person, he can't go and ask anyone. I'll give their certificate to you, you pay me money. How can it be possible? Unless he is told that on our behalf,
he is
going to collect it.
Yes.
Then I can understand he can make a demand. From the record you show me that the day when the demand was made, it was known to the accused that he is the lawyer who is handling on behalf of the 5 contractors. Show me. Otherwise, you are gone. Your case is gone. That's the link. In the light of this facts, and when you see PW2, a serious doubt is being created. Any person expression used in both the provision doesn't mean a stranger.
But in fact, yeah, that decoy has deposed that he has been authorized to get the TDS certificate on there. That part is there.
Where?
And space 29 minutes.
29
minutes.
He
says that.
He says, but how come the accused know that he is authorized? If accused know, then only he will demand, na? Accused जानता कि भाई ना lawyer ही तांकर सब काम करची ताल जाके तो demand करता था accused जानी वाला क्यों demand करियो say where from you get just show me from his evidence. Let us read out PW1 once again.
Yes, ma'am. Page 29 onwards.
Pura.
Yes.
Some sentence you may get, some sentence you may not get. I am an advocate.
I am an advocate, Bhavani Patna. I know the accused in dock. Once during the month of September 1989, 5 contractors engaged me to obtain TDS certificates from Ranjigar Block Office. The accused was the clerk in charge of Ranjigar.
This is not legal authorization for collection of TDS certificate. Engaging a lawyer is not a legal engagement. So that engagement is neither here nor there. Proceed for us.
The accused was the clerk in charge of Ranjigar Block Office to issue the certificates under the seal and signature of the BDO. I know the handwriting and signature of 5 contractors, Lakshman Kumar Naik, Pradeep
So-and-so, yes.
Kumar so and so. These are the applications marked exhibit 1 to 1/4. My lord, he recognizes the applications also filed by the contractors.
No, I'm not, I think, able to communicate with you. What I'm trying to say is,
Your
if
lordship
an
has put a
accused-
question, the accused has to know, have the knowledge that he has been authorized to collect on their behalf.
Otherwise, he can't go and ask a stranger,
I
give me
understand
money,
that.
I'll get his work done.
Man, I understand that.
That part you show me.
These are the signatures marked exhibit 1/5 to 1/9. They had authorized me to get the TDS certificate from the block. I approached the accused many a time to get the certificates after obtaining the orders from the BDO Lanjigar.
Have you
block.
placed on record authorization letter
No.
or anything?
No. Has not been exhibited.
Then
Specific question was put, he denied. He has not filed any authorization.
For this, since it is not a legal authorization, like you can give an wakalatnama.
Yes.
That also can't be done.
Yes.
This authorization should have been, I authorize so and so to collect
On
the
my
TDS
behalf.
certificate on my behalf. That, if that would have been there on record,
Yes.
then you could have said that, yes, the accused knew that
That he
this
has been
gentleman is going to collect.
Yes.
That is also not there.
Yes.
Yes, next, proceed.
Once in the month of November 1989, I paid him ₹50. I agreed to pay the balance of ₹100 to the accused in December next. Since the accused repeatedly made the demands of the balance without issuing the TDS certificates, I felt offended and carried information to the Vigilance Inspector Bhavani Patna.
See, this is very important. I felt offended. He's a lawyer. Why should he feel offended? Yes.
This is my FIR marked Exhibit 2, and this is my signature marked Exhibit 2/1. The Vigilance Inspector appointed a date for me to arrange a trap against the accused. I remained myself present at Bhavani Patna PWD ID, where the vigilance officers were available. One clerk of Settlement Office Bhavani Patna and the accountant of DI Office Bhavani Patna were called as witnesses. Mr. Samantara, Executive Magistrate Bhavani Patna, was the magistrate of the trap. I explained the circumstances about the demand of illegal gratification by the accused to the officials. I handed over 2 numbers of 50 rupees notes to the Vigilance Inspector. Magistrate took down the numbers of the GC notes in a chit of paper and kept it with him. The Vigilance Inspector prepared a solution and asked me to dip my hand in it. The solution did not change in color. The GC notes were mixed with a powder and I handled it and then I dipped my hand in the solution which turned pink. The solution was kept in a dry and clean bottle and it was sealed. The GC notes were given to me and I was instructed to pass on the notes to the accused in office in presence of one witness to accompany me. That witness was instructed to give signal by lighting a cigarette as soon as the payment would be made to the accused by me. The Vigilance Inspector prepared a note in this connection. In my presence, this is the preparation notes marked Exhibit 3. This is my signature marked Exhibit 3/1. Then we proceeded to Block Office Lanjigar. The raiding party remained outside. I and the witness proceeded to the office of the BDO Lanjigar. At my side, the accused wrote something and I passed him the GC notes in question. When the accused asked me whether I had bought the balance money, I handed over the GC notes to him. The witness gave signal and immediately the raiding party entered the office. The accused kept the GC notes in the drawer of his table. I was standing near the table of the accused. The vigilance officer caught hold the hands of the accused by hand. They asked him whether he had kept the money. The accused reported that he had kept the cash in his drawer. His hands were dipped in plain water. The plain water turned to pink color. The Vigilance Inspector took out the cash from the drawer of the accused and seized it. The magistrate verified the numbers of GC notes, which tallied with that of chit he had kept. Vigilance Inspector prepared this seizure list. Vigilance Inspector prepared a detection report. I signed it. This is the detection report marked at Exhibit 4, and this is the signature marked Exhibit 4/1. He had prepared this seizure list before me, which I signed. This is the seizure list marked Exhibit 5. Now the cross-examination. I placed the Exhibit 1 series before the BDO Lanjigar for issue of certificate in the month of September. Exhibit 1 series are those applications, my lords. Applications by the contractors, which was in the custody of this decoy, which he placed before the accused. The lordship's specific query was to know how the accused will come to know that he has been authorized. Because these applications were put before the BDO by this decoy only. Because I placed Exhibit 1 series before the BDO Lanjigarh for issue of certificate in the month of September.
Where is that?
Cross-examination, first line.
I place the X series.
1 series before the BDO Lanjigarh for issue of
in the month of September.
Yes.
The video put the signature.
The BDO put no signature on these applications, nor did he give any endorsement directing issue certificate. It was in the month of September when I met the BDO in this connection.
Okay. Okay.
At the first instance, in the month of November, the accused made the demand. The said day, I paid him ₹50 at Bhavani Patna in main branch of State Bank of India. It was not an appointed date or time to meet and pay the first payment to the accused. I cannot give the date or the weekday of such payment. This payment was made inside the bank's compound. There is none present to witness the payment. Thereafter, the accused had made demand of the balance ₹100 2 to 3 times. The place of such demand was at Bhavani Patna and at Biswanathpur, but I cannot give the date of such demand. No outsider was present when the accused made the demand of the balance, both at Bhavani Patna or at Biswanathpur. I have verbally reported it to the BDO several times that the accused had been making the demand. At no point of time, Lanjigarh BDO confronted me with the accused. On previous occasions, also I obtained TDS certificates for contractors during past years. Likewise, those applications were being placed before the BDO at first. It is
so the previous also you was doing.
Yes.
So therefore, must be having the knowledge.
Yes.
It is not a fact.
It is not a fact that during past years it will be previous occasions, the BDO was usually putting his initials on the applications and passing orders for issue of TDS certificates through the concerned clerk. It is not a fact that Exhibit 1 series was never placed before the BDO Lanjigarh, and those were manufactured on the date of detection of this case. It is not a fact that the 5 contractors did not authorize me in Exhibit 1 series to receive the TDS certificates. It is not a fact that the 5 contractors made no applications to me to BDO Lanjigarh for TDS certificates.
This is the specific suggestion.
Yes, specific questions have been put in cross, which establishes the knowledge regarding the factum of the TDS
that is covered. Yes.
Yes. The date of trap was fixed to 13/12/89. 10 days before that, I had met the Vigilance Inspector Bhavani Patna. The Vigilance Inspector, after fixing the date, had asked me to come to PWD IB Bhavani Patna by 8 AM on 13/12/89. I went to Bhavani Patna PWD IB. Amongst the vigilance officer, one was Mr. P.K. Bhanjdev in the raiding party. The vigilance officers were 5 in number along with their staff. I did not lodge a written report before the Vigilance Inspector Bhavani Patna 10 days ago. I submitted written report, that is Exhibit 2 FIR, my lords, on that date. Since the procedure of trap case was new to me, I did not lodge a written report at the first instance 10 days ago. There was a preliminary talk between me and the Vigilance Inspector in connection with the case. On the day of such preliminary talk, I came to know of the procedure and lodged a written report accordingly. Vigilance Inspector brought the water from the tap of PW.
Yes, you covered that.
Yes, ma'am.
Yes. Yes, Mrs. Pradhan.
Yes, ma'am. This part of evidence that confronted to the IO, IO said he has not stated before me.
Which part?
That 10 days, the type was the date of first sentence.
The thing which we were trying to find out whether the
knowledge
accused had the knowledge. He had sufficient knowledge because the TDS certificate, the applications were submitted by him before the video. And he is the person who has authorized. That's what in the cross examination rather it comes.
Exhibit 1 series.
But there is no specific authorization letter.
This is one part. Second part is whether application was placed before the BDO. It was not placed before the present appellant.
No, BDO is supposed to issue.
Well,
He is supposed to give
Yes,
it.
so this petition, the present appellant is no way connected with the TDS certificate. The entire procedure is, it will be placed before the BDO will examine the record and he will issue the certificate.
But
The
he is
present-
working as a clerk in the BDO office.
Yes, class.
Hmm.
Some evidence is there, he is working as cashier. Some evidence are that he was a junior clerk.
What was he?
He was junior clerk.
Do you have anything to suggest that it should be routed through him only? These certificates were supposed to be routed through him only.
He
Because
himself has admitted no signature is there. No signature, video signature is
Now,
there.
what
in
is
the
his
application.
role in this? Because you have said it is BDO's job. It has come apparently.
Yeah.
But what is the role? He is working under the BDO. BDO was supposed to, he was supposed to disburse it to you. Anything of the sort? Any suggestion, anything?
This accused has given a picture that he is going to execute that work. He will process that thing. With that impression, my lords, that
Impression, he is a lawyer. PW1 is a lawyer. Impression will not work. Unless the lawyer knows that he is the guy who is going to give. He says that I have given a complaint to BDO many times.
Yes.
He being a lawyer, he could have gone to BDO and got it. But unless you show something that it is only the clerk who is supposed to give it, BDO has signed and gave it to the clerk. And the clerk is withholding it.
And if your lordship may kindly come to that page 32, my lords.
30?
32, my lords.
Yes, I am there.
I will just place para 3 once again.
Yes.
I have verbally reported it to the BDO several times that the accused had been making the demand. At no point of time, Lanjigarh BDO confronted me with the accused. On previous occasion also, I obtained TDS certificates for contractors during past years. Likewise, those applications were being placed before the BDO at first. It is not a fact that during past years on previous occasions, the BDO was usually putting his initials on the applications and passing orders for issue of TDS certificates through the concerned clerk. It is not a fact that Exhibit 1 series whenever placed before the BDO Lanjigarh and those were manufactured on the date of detection of this case. It is not a fact that the 5 contractors did not authorize me in Exhibit 1 series to receive the TDS certificates. Here the question, a specific question was put and he says about that it is not a fact that during past years on previous occasions, the BDO was usually putting his initials on the applications and passing orders for issue of TDS certificates to the concerned clerk.
Yes, anything? What is the sentence? Sentence?
1 year, no fine.
No fine.
No fine.
And he died.
Yes. He died.
Any confiscation, anything?
29/1/2012. On 3/6/2012. During pendency of the appeal.
What is your defense in the 313? Let's see. Anything you want to point out?
Page 28, question 13.
30?
Page 28, question 13, 1-3.
Yes.
He has taken the same defense.
ମୁଁ ନା କହିବା ସତ୍ତ୍ୱେ ସାହାଣୀ ବାବୁ ଜବରଦସ୍ତ ମୋ ଟ୍ର ଭିତରେ ଟଙ୍କା ରଖିଲେ ଓ ଆମ
ଷ୍ଟାଫକୁ ଚିକେନ ଭୋଜି କରିବା ପାଇଁ ଅନୁରୋଧ କଲେ।
Any DW?
1 month.
1.
So which DW? Yes. Yes, what does he say? Is any substantial to prove this? Question 13. How the trial court and high court is, appellate court has dealt with?
ट्रायल को आगे कोचिंग जेदी जेतु आगे से चिकन पे पैसा न ले भी से आगे कन्विक्शन
It's like
yes, we have page 5.
It's like JMM judgment.
Page 5.
You take the money, but you give vote. Otherwise,
internal page 5 of the judgment.
Running page 15, man.
15?
Running page 15, man.
Okay. 1-5, yes.
The stats from last 1, 2, 3, 4, 5, 6, 8 lines.
So pura pura dono.
Even if, stats from even if Sri Sahani requested the accused to have a feast with chicken to be enjoyed by him and staff of the Lanjigad block office, such a thing is not to be reckoned at a legal remuneration. It is not a remuneration for which they are entitled. If the accused reluctantly accepted that amount to arrange a feast as proposed by Sri Sahani, that was itself a corruption.
In the same page, the court below has discussed regarding the deposition of DW1. Same page, man. I just place it, man.
Yes.
So the sentence begins with he.
Yes, office has been examined DW1, na?
Yes, office has been examined as the plea taken by the accused is not found corroborated through the head clerk. The DW1 happens to be the head clerk of Lanjigarh block. He says, my lords, he did not know if Shri Sahani was intimately known to the accused. He did not know whether they had earlier arranged and enjoyed themselves in feast of the nature that was proposed by Shri Sahani the evening of 13/12/89. He did not mark the actions of both the accused and Shri Sahani. He did not hear what they had talked together in that connection.
Then no use.
No use. Though they have roped in DW1 to prove the this connection with the decoy
So
has not been proved.
It is 13-1 sentence has no meaning. Either acquittal or dismissal. There is no confiscation, nothing?
No.
No. Okay. This is, keep it, judgment rigor, first one. It is academic, in true sense. To give short notice.
I will also, one judgment also I will file.
You give a short note and heard Mr. Vishnu Pradhan for the petitioner, Mr. Ijvi. Yeah, will you file?
Yes,
judgment heard. Sorry, argument heard, judgment rigor. In the meantime, the responsible for the parties will be filing the resolution. Not exceeding 10 pages, along with the relied upon judgment. 1 week? 1 week. Yes. So, correlation, yes. Item 10. This revision petition is arising out of a judgment of conviction and sentence dated 9/7/2009, passed by special judicial magistrate Baleshwar in ICC case number 293 of 2008, which has been upheld by the appellate court by its judgment dated 23/3/2013 in criminal appeal number 31 of 31/03 of 2009 and dash 2011 for offence under section 138. When the matter was taken up on 24/6/2024, none had appeared for the petitioner. And in the interest of justice, the matter was adjourned today. urgent to today. In the morning session, when the matter was called up, non-appeal for the petitioner, even in the second call, non-appeals. It seems the petitioner is not interested to prosecute the revision, accordingly it is dismissed. Yes. Oh, supplementary is in. Oh, well, let's see. Any matter, any specific matter want to argue?
Item 126 onwards.
Anybody want to argue? Yes. 126. Yes, madam.
Lordship, the last occasion they directed to produce the whereabout the.
Well, he is alive, madam. So I have received
Alive.
instruction, madam. He is alive.
Alive. Lordship,
The opposite of the Vigilance Department was directed by order dated 28/2/2024 to ascertain the well-being of the.
Yes, I have received the instruction from SP Vigilance,
applicant.
Sambalpur.
Mr. Rijvi submits that he has received the instruction
Dated 27/6/2024.
26/7/24 that the petitioner is alive. Alive. Proceed. Next. Yes, now.
Tomorrow.
Tomorrow.
Okay.
Miss A.K. Submits that he is not prepared. Let it be there. Adjourn.
Tomorrow.
Let it be. It comes
Yes,
tomorrow.
yes.
So fixing tomorrow at 2 p.m. madam?
2 p.m.
2 p.m.
Yes.
Yes. 127. Yes.
Number 136, my lord.
Number 127.
127. Yes.
127.
And that's in 120.
127.
That's in 127. Noting says 2 paper books are ready. So 1 paper books may be served on us.
I just see
That I will also examine from the paper book.
what
also.
is the accused.
Yes, madam.
Is
Because in the paper book, I will be able to know the consent division so that I can send the letter to the consent division house.
94, he was 48.
Yes.
94, he was 48 now. So let's count to 48. Paper book ready? 54, 48. Paper book in the present bill is ready. Copy of the registry is directed to supply copy of the paper book to Mr. Rijvi. What is his?
76.
76. Mr. Rijvi submits that he would get instruction from the department regarding the well-being of the appellant and well-being and whereabouts.
Whereabouts.
Release the matter. 15. Same.
Same 15.
Same batch.
So a copy of paper will be served on.
Copy that's
Great.
given. Yes.
128.
In the year 94, he was 51. 51.
$79. Same order also, I will ascertain.
Same order code. In the year 1994, the petitioner, the appellant is stated to be 51-year-old. So by now he is
79.
81 years old. 81. Therefore, Mr. Rijvi, counsel for the opposite party, submits that he would obtain the well-being and whereabout of the appellant. Raise the matter on 15th.
My lord, let these matters come on 18th, my lord. Some time so that we can, or 22nd will be apt, my lord. 22nd, my lord.
18th, let it be 18th. Right.
18th. The previous matter also was 18th.
18th. आज ही जुड़ा जो 15th रूट है आज ही सुबह 18th. And immediately you take a copy.
Yes, my
and
lords.
then, and if you are facing any problem, then that side you tell so that I can ask someone to.
Yes, my lords. I will do that.
But the conducting counsel, when I retired CGIF.
Whoever.
Honorable Justice Deepak Mishra was the conducting counsel.
As here, I may be permitted to have access to the soft copy, item 128.
128. Permission is not required. You can get it.
Months.
Yes.
129.
That time also he was about 49 years.
49 to 94. 79 minutes.
Same order.
Well, let's here paper books are ready. One set of paper book may be served on.
Paper book supply करते हो? Yes. All are 94 rupees. Yes.
130.
Same year 50 years that time.
80.
80. Same for. So what are the 18. Hey.
133.
No, 133 was.
133, there are 3 rupees. One of the appearing, I have for the one of the appearing, maybe.
Here also paper book needs to be served. Paper books are ready, has not been served on us.
Yes. Paper book in the appeal ready. Registry director to supply the copy of paper book to Mr. Ijvi. Please see. Let it be.
Weekly.
That will remain here.
Weekly list.
No, weekly list.
33, 34, 35, let's see. 134, 135.
All paper book ready.
Paper book not
No,
ready.
not ready.
Not ready.
Let us see 34. What is one?
The instruction and.
No instruction.
She also says that she has not got any instructions.
All participation submit that the necessary listed up after the 10,000 class.
Let her take instruction manuals from the.
Controversy petitioner seeks the adjournment to get instruction from his client regarding the appellant's well-being.
So 134, 135, 136.
3,
yes, 3, 4, 5,
already,
6.
4, 5 paper book has not been.
6 also same. 6 is. 136, my friend is appearing in 136.
Just one.
36.
36, no? Yes. Yes, sir.
Sole appellant is diagonal. Sole appellant diagonal.
Let a counsel for the petitioner submits that appellant submits that to the sole appellant. Look, right? He hands up a memo to place on record the death certificate from death certificate APS that the sole appellant has died on 16/11/2019. The memo is taken on record in view of the aforementioned development. The appeal stands yes. Next.
137.
137, let's say brief has been transferred. Kindly remove the power of senior advocate Mr. Dipidhar.
In the year 2002, he was 68-year-old. Yes, Mr. Rizvi.
Ballots. 2002 minutes.
68.
68. $88 minutes.
In the year 2002, when this appeal was filed, the petitioner was 68 years old. Substituted by 62 years. Sole he died. So the wife substituted. Wife filed. She was 68 that time. This Let it be there. Let it be there. Yes.
139.
2004, he was 64 years. 63 years. 2004.
83 present.
When the appeal was preferred in the year 2004, the appellant was 63 years. Therefore, the opposite party, Vigilance is directed, he will give you the SP name, directed to seek instruction regarding the well-being and whereabouts of the appellant. So, correct. All 18, yeah?
So called adjourned. 140 has been adjourned in the morning.
When
141.
141, let's say, I have sole appellant has died and I have filed in IE for a substitution and the condonation of the bill.
IE
number 143 of 24. 144 of
Offense?
31E.
He is also 77 years old.
That's already died. Appellant already died.
They filed a
No.
IF for substitution and.
I know.
Minutes.
The appellant's wife
There are.
seeks
There are
substitution. She is also 77 years old.
Ready for hearing.
By the time you hear, I don't know. Let it be, be ready to argue.
Yeah, that's it.
If you,
It
if
about-
anything is there, it's all right. Otherwise, see, why should we, hear this matter? If-
Next week, any day, complete.
Just see whether anything is there.
Allow the substitution.
Let it be there on the report. 140? Both, let it be there.
142.
Hmm?
142 is,
2000,
Weekly.
see, 2004 when you filed it, that time the appellant was 62-year-old.
82.
Came out of water.
143.
One 40.
143.
He was 55-year-old in the year 2004. Just tell me whether he's alive or not. Brahmananda Savar.
Let them take Let them take instruction from the clients.
Let know that for the petitioner submits that you seek the instructions regarding the well-being and whereabouts of the petitioner, because in the year 2004 when the appeal was filed, he was 55 years old. Please the matter.
144.
Hmm?
Continue.
Sorry?
144, continue.
Let it continue, but what is this matter about? Conviction,
Appeal against conviction.
is he alive? Sure. In the year 2004, he was 60-year-old.
Instruction.
Let him take an instruction.
Let him take instruction. In the year 2004, when the appeal was filed, the petitioner was 60-year-old. In that view of the matter, the counsel for the appellant takes time to get instruction from the client regarding the well-being and whereabouts of the appellant. Seek instruction and tell.
Yes.
Otherwise, I'll abate everything without waiting. Yes.
145.
Let's here 145 paper books need to be served.
Paper book
need to be served. It's ready.
Paper book, paper book is ready, sir. And here also nobody is appearing and you have to seek instruction. He was 52-year-old in the year 2005. Seek instruction. What will I do?
146.
Yes, sir.
Take instructions.
Take instructions. Instruction regarding what?
Live or alive.
Huh?
Appellant was live or alive.
Here, of 2005 when the appeal was filed. The petitioner was 54-year-old. The legal counsel for the petitioner appellant. Legal counsel for the appellant submits that the seek instruction regarding the well-being and whereabouts of the appellant. Read the matter. There will be 2 weeks. Yeah.
147.
Yes. Whereas appellate counsel is sitting this side. Appellate counsel is sitting this side.
Now at least tell whether he's alive or not.
That instruction would have.
Last material instruction when you got.
It's long while.
Get instruction because he was 50-year-old in the year 2005. Him himself. Yes.
149.
I have to seek instruction as of date. He would have been 81 years old. I have to seek instruction if he is alive or not. This was a trap case under section 7 of PC Act.
Year 2005 when the appeal was filed, the petitioner was 62-year-old. Therefore, the appellant, counsel for the appellant seeks 1 week time to get instruction regarding the well-being and whereabouts of the appellant. Reach the matter after 1 week. Within 1 week, you have to.
Millers, we have to send handwritten letters. Millers, some more time maybe.
Not necessary. Why?
Millers, we do not have phone numbers. The 2005, we do not have phone numbers. It was a matter.
You tell me.
Millers, just 2 or 3 weeks.
No. You tell me the which area HP.
Millers. This is of district Ganja, Millers.
Ganja.
Ganja, we don't have a division.
Vigilance case. Vigilance case.
Vigilance case.
You tell me which vigilance.
Barampur division.
Barampur.
SP.
Barampur SP.
Barampur
SP. He'll seek instruction. Put it on 18th. Before 18th, you also seek instruction.
Copy of the order.
Copy of the order.
Onward transmission.
Yes.
150.
And 1 minute, Mr. Rijvi, if you are getting information regarding any matter where the appellant is died, 15th I'm keeping all.
Yes,
and a couple of matter fixed on 18th. You are
Yes.
getting information, then you can inform so that I can take it up and
Immediately I will inform. Yes.
including the
This
weekly
fresh
and-
list matters.
Yes.
Appellant already died and substituted. Convicted under section 13(2) and 13(3).
Already substituted.
Substituted.
Yes. Convicted under
13(2), 13(1)(d) and 7 of the
Hmm.
PC Act. The sentence to SI for 1 year and a pay of fine of 1,000. There are 5 witnesses are examined. PW1 is the preparation and the detection report. PW2 is the accompanying witness. PW3 is the complainant. PW4 is the sanctioning authority. PW5 is the investigating officer. In the case. The case is the prosecution case is the appellant demanded 500 rupees from the complainant for release of the bicycle and the fare wheel. The appellant is serving at the forest guard. PW1 is the preparation and the detection report. You kindly see the PW1, evidence of the PW1.
Yes.
Cross-examination is running case, paper book running case 40. Paragraph 7.
Reach we ready?
Paragraph
No, no.
9.
They're not ready.
Serial number 150, my lords. I thought she's just giving a brief summary. I don't
No,
know.
he is not ready.
Small.
A small matter, but it's big for him because he is not ready. Let it be there. Let it be there. You get ready. Small matter.
Yes.
Let it be there. You have paperwork and all?
Yes, yes.
Yes. Get ready tomorrow, day after one. Whenever you get time.
No, day after tomorrow, you actually have already fixed 2 matters.
Let it be there. If you can get time, we'll proceed.
11th, you're actually.
Yes. Let it be there in the.
Yes, ma'am.
Yes.
151.
150.
151.
And that's my suggestion from, I think from 151 onwards, we may take it from tomorrow.
Okay, till 150.
Yes. More than a century.
Yes. But anybody in the revision matter? Okay. A revision matter, if anybody is there.
Item 26 and 29.
If it can be over, we can do it. Old matters?
Yes, ma'am.
Very old matter or 20?
26, ma'am.
6.
This is revision against conviction, ma'am.
Yes. You are there. Huh?
During pendency of this revision, ma'am, the petitioner number 2 died, ma'am. Now it's confined to petitioner number 1 only.
1. Okay. What is the offense?
Offense under section 7 of Essential Commodity Act, ma'am.
6
month conviction, ma'am.
6 month conviction.
6 month conviction. On merit also, my lord, I have a case, my lord. There are 4 witnesses, my lord. Out of 4, my lord, 2 have been hostile. And on the basis of the PW4, my lord, case has been convicted, my lord. PW4 is the informant as well as the investigating officer, which cannot be, my lord, in view of the Mohanlal Chupra case, my lord.
This type of cases, my lord, what happened one person.
See, how many witnesses?
4 witnesses, my lord.
4 witnesses.
2 have been declined hostile. They did not support it.
And IO is the informant.
Informant, marketing inspector.
And who is the other one?
Other one is a seizure witness, my lord.
Seizure is proved.
Yes, my lord. And most interesting, my lord, from whose possession the contraband article has been recovered, they have been acquitted by the court below.
Yeah, the way is super stockist na.
Good, actually. नहीं भी जाते हैं.
Date
Title तो नहीं जाते हैं.
Mercy.
Mercy होशी ये मनोज कुमार के लिए.
Dead.
Now, Nilkant suddenly died.
No. Suddenly is alive. Manoj Kumar killer, he died. And this petitioner were convicted on the basis of the statement of co-accused Shyamabhanu Pujari and Sanjay Kumar there. They have been acquitted by the court below. Since, my lord, they stated that, my lord, they are
working as a labor under these
They are also co-accused.
But they
are also co-accused.
They have acquitted on the ground that they have only working as a labor under them, my lord. And these petitions, my lord, given the 300 liters of kerosene to them. For that reason, my lord, when the IOP 4, my lord, he came to this. I read out the one paragraph, my lord. Pidol 4 is a public servant. He deposed in this case.
Paragraph?
Page 15, my lord.
15.
Second paragraph.
15 internal page.
My lord.
Additional stations.
Pidol 4, madam.
Okay. No, say trial court, you are ready?
My lord.
Trial court judgment?
My lord.
Okay.
Trial court judgment, my lord.
Pidol 4 is.
Para?
Para 6.
15. No. Not para 6. My lord. Para 7, page 13, para 7.
Yes. PW4 further depot.
Further depot that 19 to 2000, he found the accused Nilakanta Sarangi, who is alive, my lord. Nilakanta Sarangi.
Normal
Running by 13, man.
Suddenly he died, no?
No. Nilakanta Sarangi, he alive, man.
Alive.
And Manoj Kumar, he died. Yes, ma'am.
He
on?
Died on?
Died on that instruction.
Died, okay. He died.
Paragraph 7. trial court judgment.
Para 7, yes.
My lord.
PW.
PW 4 further deposed that on 19/2/2000, he found the accused in record serving the present petitioner, my lord. And on interrogation, he stated before him that one person, namely M.K. Khilo, who has been expired, expired. The government retailer of colony number 8 has delivered 300 liters of kerosene to him. PW 4 recorded the statement of the accused Nilakanta Sarangi by Exhibit 6. On the same day, he proceeded to column number 3 and inspected the retail shop of accused M.K. Khilo. The said accused could not produce any stock of kerosene of the account nor any measuring instruments. The accused M.K. Khilo admitted before PW 4 that soon after purchase, he delivered the stock kerosene to the accused, the present appellant, Nilakanta Sarangi. The said accused M.K. Khilo further stated in his statement that during the purchase of kerosene from wholesaler, he paid 700 and rest amount was invested by accused Nilakanta Sarangi. PW 4 deposed in paragraph 5 that the accused M.K. Khilo further admitted that the accused Nilakanta Sarangi used to manage his retail shop and used to transact in the same manner. PW 4 proved the confiscation statement of the accused M.K. Khilo, Exhibit 7. PW 4 went to ahead stating in para 6 that on 22/2/2000, he proceeded to the house of accused N.K. Sarangi, the petitioner, and on demand the said accused produce the retail license number 21 valid up to 31/3/2000 issued by sub-collector Jaipur in favor of the accused M.K. Khilo, along with cash memo number 40 dated 15/2/2000, showing the purchase of 300 liters of kerosene from the wholesale dealer issued to the accused M.K. Khilo. After about 10:30 a.m., he seized the same along with one barrel containing along with 200 liters of kerosene, one tally register, one stock register, and one sale register belongs to the accused M.K. Khilo. He also proved the seizure list by Exhibit 3/2. He recorded the statement of the accused Nilakanta Sarangi and proved the same as Exhibit 8. The prosecution alleged that accused Manoj Kumar Khilo violated the Clause 11 Orissa Kerosene Control Order 1962 and the accused Nilakanta Sarangi violated Clause 7(1) of Orissa Kerosene Control Order 1962, punishable section under Section 7 of Essential.
Then this evidence shows that the petitioner is an employee of the accused. Retailer name stand in the name of Manoj Khilo.
He was managing everything.
That is the allegation, my lord. But in fact, my lord, the petitioner was working under the
But
Manoj
what is
Khilo.
the evidence? PW 4 says that. And the strength of the prosecution is the only confessional statement of accused.
Accused and that has been recovered. That has been material has been recovered.
No.
That is the
Recover was made from the other co-accused who have been acquitted, my lord.
They stated
On
that
their statement, my lord, this
they
petitioner
received
implicated.
the 300
And most interesting part
from
is,
this petitioner, my lord.
and most
That is
interesting part is that, my lord, the investigating officer should not be the informant, my lord.
No,
In the-
Section 7, let us see, Section 7. Investigating officer should not be the.
IO should not be the informant.
Section 7, huh?
Section 7.
Section 7.
Here, my lord, he is not a police officer, my lord.
No, that.
When the police officer, my lord, that is the law. When the police officer is himself as an informant and IO, that case,
in
my
a
lord.
vigilance
Here,
case
my lord,
also-
here
in a vigilance
7
case
issued
also
there,
he-
my lord.
Yes.
Here, my lord, the petitioner, the IO, who is the IO, he is the marketing inspector.
But that
So
should
he
not
is
be.
competent to investigate
No,
the case,
no,
my
that should not be which was
No,
held in
he-
Mohanlal case, my
He
lord.
is the investigating officer.
Yes,
My
my
lord,
lord.
he is investigation
For the
except that
purpose of essential.
he he is essential competent. He is competent, my lord.
No, no, no.
Otherwise, police
In
is
view
not
of your
valid
lordship, may
investigating
kindly
case,
have
my
a
lord.
glance in the Mohanlal case, my lord. In the Mohanlal
Mohanlal.
case, my lord, that part has been dealt, my lord. In the PC Act also, my lord.
The PC Act, here, my lord, what happened? He himself the marketing inspector, my lord. For that reason, he lost the information.
But
And
he-
he lost the case.
Come to page, section 7. Which provision was invoked against you?
Only section 7, my lord.
Section 7, many provisions are. Three months is minimum
My lord.
sentence.
My
And it
6
can be
months.
extended to 7 years.
7.
6 months in.
6 month conviction.
6 months. Fine, 5,000 fine.
I've given the judgment also, my lord. The Mohanlal case judgment.
That I know.
Right.
Yes.
And most interesting that, my lord, the independent witness, they have been turned hostile. PW 1 and 3.
Give probation what?
And beg pardon.
Give probation.
Hmm.
Give probation.
Judgment.
Then,
And what is his age?
then when the trial is vitiated, my lord, how the conviction will sustain, my lord?
Oh.
Trial is vitiated. No, siege, that is a different matter. But the informant should not be the investigating officer. That is the settled position of law. Till now, that has not been.
Here he is not on
Essential
police officer.
Essential community act you in the
In
context.
all case that has been dealt, my
Only
lord. In
marketing
the
inspector competent.
No, show me essential community act who will be there. Investigating officer.
Nice.
Come to the. Definitely.
And it is specific case that the statement of accused MK Kilo, but 87 revealed that the accused in the petitioner used to manage his retail shop, they used to transact the same manner.
in that
So
effect,
he is
well,
responsible.
no independent corroboration, my lord, to that effect. Independent witness, they have been turned hostile.
What Mr. Mishra is arguing, basically 2 points.
Madam.
One is the investigating officer can't be the informant can't be the investigator. First. Second is except the investigating officer's testimony.
Right.
The other testimony which is used is the Kilo's confessional statement.
Right.
Co-accused confessional statement
And
cannot be
also,
read against him.
and also his statement, madam.
And
The petitioner's confessional statement also exhibit 7, madam.
That's right.
Madam.
And third point is the seizure which you are alleging, that is made from the other co-accused person, those who have been acquitted.
They acquitted, but they confess that they have received from the
co-accused confession.
They confess that they have received from this petitioner, madam.
So that means accept the confessional statement of co-accused person, and you have nothing.
We do 4, madam.
If that is taken into, if that is taken into, yes, my lord. And if that is taken into consideration, my lord, I am mere an employee of the principal accused, my lord.
Specific, my lord.
Specific. And the license stand in the name of the Manoj Kilo.
You to manage retail shop and they,
yes.
They use the transaction of the same manner, madam.
Management, that means I am an employee of the shop.
And to the
dealership stand in the name of Manoj Kilo, my lord. Not in me.
In the act, whether the investigating officer or authorized officer is explained.
Madam, I only one submission, madam. With respect, the statement of 2 appellants, these 2 petitioners, Exhibit 6, 7, 8. Man, 6 is the co-accused man, 6, 7, 8 are certainly their admission as defined under Section 17 of Evidence Act, my lord. And for ready reference on under Section 17 of the Indian Evidence Act.
Where are you reading?
My lord, the page 20, appellate court judgment, my lord. Appellate court judgment, page 24.
Yes, 24.
4. Paragraph, my lord, 4 paragraph, 24, last part.
Yes.
Last part. Continue paragraph. The statement of a two appellant provided exhibit 6, 7, 8 are certainly their admission as defined under section 7 of Evidence Act. For ready reference, section 17 of the Indian Evidence Act is quoted below. Admission defined. An admission is a statement which suggests any inference as to any fact in issue or relevant facts that which is made by any of the person and under the circumstances hereinafter mentioned. Those admissions are relevant under section 11 of the Indian Evidence Act as against them. So one of the
attention to the evidence of all the four prosecution evidences, the result of the same would found that the independent witnesses
that part deal by the
not
trial court or the appellate court also. With regard to admissibility of their
natures
statement.
And seizure list of prosecution has not declare them as hostile.
And the
seizure list of genuine document
and the seizure list malad accepted as genuine document. Similarly, evidence of Jimadar examined as Pidol 2 could not be settled in cross-examination settled slattered in the cross-examination so as to disbelieve. The fact that that has been seized and that has been taken Jima, the Pidol 2 taken Jima, my lord.
Yes.
How
will you get over this findings?
Cannot, my lord. Except, my lord, that pure nothing.
You can't get over this findings.
Except the statement of PW4, my lord, there is no mention. When the independent witness...
No, the independent witnesses have admitted their signatures. That part is not denied.
Exactly.
Seizure is also proved. According to the finding of the appellate court.
But they have been turned hostile, my lord. They have not supported. Trial court dealt that.
The trial doesn't mean that their entire testimony will be thrown to the
statement of the, your lordship, see the findings of the trial court, my lord.
Come to the appellate court finding, it says the independent, see, it's perusal of the same, found that though the independent witnesses to the seizure have not supported the seizure of kerosene, but they admitted their signature on the seizure list, and the prosecution has not declared them as hostile.
Even
That's
that, even that is taken into consideration, my lord. The dealer's name stand in the dealer's name stand in the name of the another accused, my lord. Sorry, that Manoj Kumar Khilo.
This petitioner so responsible. He is managing my all.
No, managing that means that I am an employee. Managing means I am just an employee.
Given all this, my lord.
Our stand in the court below is also that.
In this case, the seizure is accepted to be genuine document.
Yes, my lord. Yes, that is true. But my stand in the court below is that I am mere an employee of that shop.
Not employee. He has managed everything.
No, manage, that is the prosecution allegation. Allegation of the PW4.
Be happy that you won't be going to jail.
That is why, my lord, the Mohanlal case came into force. Yes, my lord. This is the reason. For that reason, my lord, the Mohanlal case came into force.
Mr. Sankar license. Mr. Sankar license.
29.
And to death of that,
I will record his statement.
Yes, my lord. My statement.
And what is the age of this gentleman?
By the 50 years, my lord. By the time of
expert 45
No, 26 at the time of filing the revision, he was
No, 50 thala trial wale 50 thala 2001
2001.
Yes,
a trial had taken place when
trial was
2009 re trial judgment hala 17/7/2009. By the time judgment hala 50 years
50 thala ta 45 thala Manoj
kilo 50 thala
50
now he is alive, man. I have taken instruction.
No, alive, but what is the age?
75 now 75
65
sorry 65.
Okay.
29.
The petitioner has been convicted for 7 years for the offense under section 376, madam. And fine of
376 it will take little time. Let it be there. We will hear it.
How about
if any small matter is there?
47.
Huh?
Item number 47. At the
47.
convicted under section 341 and 24, my lord. The
Sorry?
period convicted under section 341 and 324. The period of detention is 2 months only, my lord. And 200 rupees fine.
Fine.
200 rupees fine.
What was the sentence imposed?
Sentence imposed 2 months for the offense under section 324.
324, 2 months.
2 months only. Your lordships can turn to page 48, the appellate court.
Mr. Ragada, just see this.
My friend, Mr. Mishra.
Page 49.
40?
Page 49.
49.
Yes, ma'am. Initially, my lord, trial court convicted under section 341 for 7 days.
7 days?
Yes, my lord. And next, the higher offense that 341, 324, my lord, that 2 years. Subsequently challenged the appellate court. Appellate confirmed the partly allowed the
Can confirm, consequently, the appellate is directed to pay fine of rupees so
200 and 2 months.
Go SI of 2 months.
Yes, my lord.
Yes.
And all other accused person also in meantime acquitted, my lord. That period now.
For 2 months, you have not undergone any period.
No, my lord.
My lord, PW6, who is the injurement?
Leave it PO. What is it?
The political dispute case at the time.
It will reserve PO kar do. 2 months sentence, why? Conviction maintained. Leave him in PO.
Right.
2 months conviction. PO karke chhod do. Yes. Anything? Yes, 110. Yes, sir.
It's going to be convicted for 2 years.
Hmm?
For the offense under section 498 years.
498?
Yes, madam.
Yes. Husband?
Husband, ma'am. 110.
Yes. You are the husband?
Yes, ma'am.
Convicted by both the courts?
Convicted for 2 years by the trial court. It was modified to the extent 6 months.
By the appellate court?
By the appellate court.
When you filed in 2015, when you filed this revision,
yes,
that time you are 43. Yes. Government employee?
No, madam.
Who is a 498A?
Yes, sir.
Convicted? Husband. 1 year sentence by the trial court.
Yes.
Appellate court converted to 6 months.
6 months.
In 2005, this revision is filed.
Yes.
That time he was 43 years old. Today he is 43 plus how much? Just about 43 means today must be
62.
62. Why should you send him to jail? PO? इसको PO करो. Conviction maintained? Sentence. Probation of offender check. Benefit, yes.
Item 31.
31.
Yes, sir.
The only problem is writing so many judgment is the only problem.
Difficulties, because you have to write all the things.
Small process.
But for you have to write something. Yes. Yes. 30?
31. This matter, the appellant was convicted for 3 years and subsequently he filed an appeal. In the appeal, the sentence was reduced to 1 year for the offense of under section 324.
324.
324. Fact of the case is like this, Your Lordship. What happened? 2 persons.
Forget about fact, you show me the injury.
Yes.
Injury is not in
regarding
by
intent, because of sudden provocation, Millard, intention and motive part is not there. Why I am saying so, Millard? Because 2 persons were quarreling in between.
Are you trying to?
No, my lord,
you are trying for an acquittal.
No, my lord. Here, what happened is, my lord, P-Dole 1 is the informant, my lord, and victim, my lord. P-Dole 5 is the doctor. P-Dole 5 doctor on page 6, running page 16, my lord. 16,
1/6,
my lord.
yes.
Schedule 5 is the doctor who had examined the injured on the day of occurrence and located one incise wound on the right shoulder, which has been caused by a sharp cutting weapon. So the medical evidence supports the prosecution case. And Schedule 1 is the injured, my lord.
Injured.
My lord. He categorically stated that this petitioner is responsible. Schedule 1, my lord, page 12. Paragraph 6. Schedule 1 is the informant and the most important witness of this case. He has identified the accused. The evidence reveals that on 9/9/2004 at about 1:30 p.m., accused Sunil Behra and one Mohan Das of his village were quarreling among themselves. He intervened in the matter. He has stated that accused Sunil Behra abused him, saying, fill the language. Devi brought out a bhujali from his pocket and gave a blow on his head. As a result, he raised his hand and the handle portion of the bhujali hurt in his head. Further, he has stated that accused gave a second blow to his right shoulder, for which he sustained bleeding injury. He stated that Mohan Das and Priyavrata Mahanti took him to Bhapur Hospital and lodged the affair as an outpost.
Mohan Das is examined.
Mohan Das, my lord.
He is the sole eyewitness. Mohan Das is examined. Yes, PW2.
My lord. PW2.
Just see PW2. What is it?
Because of political rivalry, it was stated there that the appellant is belonging to BJP and the
Come to
PW2, page 14. PW2 Mohan Das, who is a witness to occurrence, and he knows the parties. He has stated that accused quarrel with him, and when Bhavagrahi intervened in the matter, the accused brought out a bhujali from his garment and gave blow to the head of the injured, and the injured same.
I only page 20.
PW injured is PW1 and corroborated with the PW2 eyewitness.
And
doctor's evidence also corroborates with this. What else remains?
In the learned court bill has punished him for 3 years imprisonment. The appellate court has reduced that to 1 year.
You should be happy.
That too, Your Lordship, the relevant portion is at page 28. I may be permitted to read out. As regard to the sentence inflicted on the appellant, it is borne out from the record that the incident took place due to sudden quarrel ensured between the appellant and the one Mohan Das. He is the intervener. Victim is the interfered into. On intervention by the victim, the appellant assaulted him. There is no material to show the appellant had any previous record of conviction. Taking into consideration the above fact and circumstances of the case, the nature of injury sustained by the injured, and the age of the appellant as well, I am of the view that it is not a fit case to extend the benefit of PO Act in his favor, but sentencing to RI to 1 year. They have reduced.
Rate there you did not get, you will get it here.
89, my lord. 89.
How much you have already undergone? Have you undergone any time?
3 months.
3 months already undergone?
Yes, sir.
Write down. Give the periods of undergone.
Yes, I'm giving.
Write it down and give.
I'm giving.
Right now you give. Otherwise, this is
No, right now.
Date of custody, date of release.
Yes, sir.
Give. Yes.
89.
Slip in it. Take it. 89.
My lord, the petitioner convicted under section 457 380 and sentenced to undergo RI for 2 years.
89, na?
My lord.
Yes.
In the appeal was dismissed. And
2 years sentence.
My lord. The stolen article are utensil, cloth, rice, cash.
Are you aiming at a acquittal?
7/18
Acquittal be ହେଇପାରିବ କାହିଁକି ନା PW2 and 3.
Then I hear you tomorrow. Be ready tomorrow. We'll try if possible equitable, if it is possible, then we'll see, otherwise.
I will not
Sentence.
available.
Gotti line
After
खाली Gotti line running page three of the judge
I'll
bench.
hear it by 4 o'clock. I'll hear it tomorrow. Be ready, huh? Tomorrow.
Item 49, only 6-month conviction.
49. ये Mr. Goda.
6-month conviction, my lord. 325.
49.
49.
Offense.
Offense, my lord, 325 by 34 and other offense.
325
by 34 offense.
Come tomorrow. We'll just
Public.
see
Yes, ma'am.
overall. I have to give details.
More, my lord, the routing will be, my lord, the from item or will be taken up.
Yes.
That's no.